Good morning, everybody.
Good morning, Your Honor.
Mr. Suleiman, would you be kind enough to call the case on, please?
Yes, certainly, Your Honor. The hearing is in the matter of CFI 79/2021 before Justice Michael Black. The claimant is represented by Stephenson Hardwood Middle East LLP, and the lead counsel is Adam Temple. The defendant is a litigant in person and is represented by Raj Kamath. Thank you very much.
Good morning, Mr. Kamath. Good morning, Mr. Temple. There are a number of housekeeping matters that we have to deal with first. Mr. Kamath, the first question is your rights of audience to be able to address me today. In your written submissions, you have obviously made the point about the representation of corporate defendants by an individual. If you're right about that, you can't address me at all today unless I give you permission. I assume you want to address me today and therefore would like me to give you permission to speak today.
Morning, Your Honor. Hope you're doing well. Clause 35.42 says that as a corporate officer, I cannot address you till 35.44. You give me the authority or sanction to do so under unusual circumstances, it calls.
Well, I'm quite willing to do that today.
Sure, sir.
So we needn't waste time on that if you're content with that.
I am, sir, on the current application that is in front of you for application.
Okay, good. Well, that's the first point. The second point, Mr. Temple, is this. Yesterday, there was a fourth witness statement of Mr. Sharrett's, of which I'm sure you're aware, and subject to any objection from Mr. Kamath, given that it responds to points which were only raised in the second witness statement of Mr. Kamath, I would be minded to give permission for that to go on the record. Do you have any objection to my admission of that further witness statement, Mr. Kamath?
Well, so do the rules allow this, sir?
They do. Basically, the rules allow me to do what I want, as long as it's just.
Let's get on with it, sir.
Yes, indeed, that's a very sensible approach. Thank you very much indeed. In which case, we'll admit that fourth witness statement. And so in that case, the first order of the Mr. Kamath, for some reason, I can only see half your face.
Sorry, sir. I'll move that along. I've got my laptop in front of me, which has got everything on it. So
yes, you've gone the wrong way. If you could go.
Your Honour, if I may, maybe just the shape of your Teams window. I can see all of Mr. Kamath.
Can you? Okay.
Let me see if
seems to let me see if I can change it. Let me see if I can change.
I didn't want to say that.
Gallery at top. It doesn't help me.
I have it filling half a screen, and for some reason it gives me two landscape views. But anyway.
now I see Mr. Kamath perfectly. Thank you very much indeed.
Your Honour, if I may, before we get into the meat of the matters arising out of those two preliminary issues, I wonder whether it would just be worth clarifying Mr. Kamath's position in respect of the individual defendants. That would be defendants 3 and 4. Again, we don't oppose him in a sense being a lay representative. I can see that one of the other defendants, Mr. Sridhar Malakode Vaidyanathan, is in fact in the room.
Yes.
I just thought it worth clarifying for the record.
I see that. I had anticipated that effectively Mr. Kamath would be a Mackenzie friend, but with the exceptional position of being allowed to address the court, because obviously under English procedure, and I think Australian and Irish too, it's rare that a Mackenzie friend is allowed to address the court. But I thought in the circumstances that would be appropriate. So Mr. Kamath, sorry to use a technical phrase, Mackenzie friend, what that means is it's a lay representative of other litigants in person. Normally, they're not allowed to address the court. But given the circumstances of this case, I would be perfectly happy for you to address the court on behalf of the other human defendants if they want you to. Is that all right?
Shouldn't be a problem, sir.
Okay, all right. I think, Mr. Temple, that clarifies the issue that you raised. In which case, we can then get on with the business of the day. Mr. Kamath, it's you to go first.
Yes, sir.
To explain to me why we should be adjourning the application for immediate judgment. I can tell you I have read everything in some detail, so you needn't go into the grinding detail. You can go for the headline points and what you think are the most persuasive arguments that you have.
Sure, sir. Thank you. Firstly, I think I need to address you as Your Honor, so I just wanted to make sure I don't cross any lines. So, Your Honor, as far as I'm concerned, as far as the Part 2023 application is concerned, if we have to frame the issues at hand, I'd like to address it to the core of the issue being that we were not able to, it started off with saying that we were not able to hire a proper legal person, for a lack of a better word, who knows DIFC and other things back last year in September 2021, owing to the freezing of the bank accounts in October. This is what the claimants have claimed.
Yes.
Now, when that happened, we did not know that had happened, to be very frank. Our checks started to bounce here for what we need to pay for the local sponsor, the lease, and all of a sudden we had to go back to the bank saying that, what is happening? What is the story? They said there's a lien mark to it worth around 40 million dirhams. And we were taken aback. We thought that the only 40 million dirham lien could be from Ransasia Capital, our lenders. Now, as you might know, sir, in Dubai.
Sorry to interrupt, Mr. Kamath. You tell me that, but the bank statements you've produced show no activity on either the AED account or the dollar account for the preceding 8 to 10 years.
No, sir. What I've shown you is a redacted statement, sir.
Yes, the dates are still in there, and there are dates that you have shown me that finish in relation to one account. I think we can look at it in a moment. Some 8.5 years before August of 2021, and the other some 10 years before August 2021.
That was my mistake, sir. I did not want to load you up with 45 pages of statement. I gave you the first statement to show that Mados Trading is the name of the company, that the bank statement belongs to the company, and the last page, sir, to show the amount of activity in it. If the court determines that I need to submit the entire bank statement of both of them, that runs over 40-50 pages, I'm more than happy to do this.
No. It's just I don't want to make sure that I'm misunderstood, that the companies were dormant between the 10 years prior to the events in question.
Definitely not. I was showing to the claimant that it is just not about at what point in time there was 4,800 dirhams, sir. What I was trying to show that money has been flowing through the account. It is not that their argument was that you did not have the money. So did it really matter if you froze the account or not?
Okay, well, we'll come to that. We'll come to that because that's an issue on the main event if I allow it to go ahead. So let's just focus for the next sort of 20 minutes or so on the application to adjourn.
That's correct, sir. So when the main matter remains there at the freezing, wherein we could not pay for our legal representation. On the 16th of November, Your Honor, 2021, I sent a proper letter as per Part 19 of the RDC, requesting all information relating to this freezing or attachment order, as they call the provisional attachment order, seeking what exactly is happening.
By that time, you had representation, though, because you wrote to the court on the 23rd of October saying we have representation.
No, sir. I addressed it myself because I believe.
I know, but you did inform the court on the 23rd of October that you now have representation.
Sir, this is about. Yes, sir. But the representation was me because even by that time it was.
No, you said we have now secured representation. There's an email to the court on the 23rd of October that says that.
23rd of October 2022 or 2021, sir?
2022.
Right. On 2022, sir, October, I had confirmation from a very senior lawyer of the Indian High Court in Kolkata that he will be representing us because he's representing us in a couple of things in India. Now, he was on holiday then. By that time, he came back, but it was the court holidays, which I have also sent in the email.
So you had funds, sorry, forgive me, you had funds then to instruct him in other matters in India?
That is correct, sir. We had, because Indian lawyers don't cost as much as Western.
That's not my experience.
Okay, sir. It is ours. Maybe we don't hire the 5-star gold plated ones, sir. We represented by people that we trust.
Okay.
So he agreed, and then he came back on the 4th or the 5th of November, and even on the 8th of November, you would have seen an email from me saying that I'm going to apply for a Part 23.46. At that moment in time, that 23.46 was to extend our ability to reply. Now, once the senior counsel came in, he looked at all the documents once he's come back from the UK, and he realized that he could not do it because the defense filed by me was, I don't know the word, but it was verbal diarrhea, Your Honor. It was horribly written by myself because I'm not trained in it.
I think you do yourself an injustice. I found it quite coherent, and I found the points cogent that you raised.
I did not raise point of law as per Mr. Sharrett's witness statement, sir, which he applied in December for application of the immediate judgment application, and I agree with him, sir. I did not make those points like a true legal professional with so many years of experience.
Yes, no, I think that was a slightly unkind remark. I found your defence raised issues that I understood.
Thank you, sir, for your compliment. But some points were too long. It didn't address what laws were being broken. I didn't. Right now, I'm comfortable with what I've submitted in 2022, sir. Not in 2021. He's right in some points. So, anyways, moving on from there, sir. The point that I'm trying to get here is that my rights as a defendant were taken away there. The ability to raise a proper defense for the company using a proper lawyer. Those are the rights to a fair trial were taken away. The only thing I've been asking, Your Honor, is the ability for a proper defense to file. If you give me the permission to do so, within a week, the new counsel will take over from India, who will then write up the defense.
Can you explain to me why you haven't put in a draft defense drafted by your new senior counsel so that I can see what the defense would be if I permitted that to be to go ahead?
Well, sir, both those, we've got two lawyers, sir. One is the High Court in Kolkata. He also represents in the Supreme Court, and the second one is from the High Court in Madras, as they call it, or Chennai. Now, both of them have said that some of this they put together, sir. This Part 23, some of it was vetted by them. They wanted the defense to be filed properly before they went into the skeleton arguments that are supposed to be put together again. So
but
again,
the usual practice, if the usual practice is to put a draft defense in to show the court that there is a genuine defense that should be allowed to go forward.
Right, sir.
So I was just wondering why they hadn't done that then.
Because they have not taken up the case, sir, as they call it in India, because there is a certain procedure to be able to represent in the DIFC courts, which Mr. Temple will probably be able to tell as well. You have to have papers submitted to the registry, which I took all the information and gave it to them. We have to give all the oral arguments you've done, and all those procedures have to be followed by payment of fees, etc. All that is pending. When they saw the defense filing, the first thing they told us, because in the defense filing itself, I've said that I need pro bono lawyers to help me with this defense.
So have those lawyers made application to be admitted?
No, not yet, sir.
I see.
Not yet, sir. They are preparing, because one of them got offended. One of the lawyers got offended because he represents in the Supreme Court. He said out of Kolkata, saying that I am not some, and again, the egos come at play, I suppose. I'm not some common lawyer here that you're asking me to put together a list of litigation I've done, oral argument. But I said that is what DIFC needs, for you to be on it. The second one is a bit more amiable. So that is what I've been battling, sir.
I see.
Again, nobody wants to pick up the pieces of a defense filing that is written the way it is written by myself. They want to do it themselves and then go ahead.
Okay. Anything else you wish to add?
Well, sir, whatever I've said in all my representations in the case, sir, over the past week or 10 days. There's jurisdictional clauses that have been breached. There is a freezing order that has been achieved from a different jurisdiction, where Article 22.22 from DIFC clearly says that they can get it done from yourself, sir. From DIFC, it's easily done. I do not understand this clandestine method in which they've gone about with the attachment order. I've requested the attachment order on the 16th of November 2021, sir. Was denied as per 19.6. Even that is not a coherent argument for not providing me with the details that I've requested. Then this year they've come back and said that you don't need to be serviced those documents. Why not? I've asked for it. Isn't there a duty of disclosure about what is happening? 6 months it was frozen, Your Honor. 6 months. Without even we didn't even know, even now we didn't know which court they've gone to get this done. I can go into the details about how many rules of the UAE onshore federal law has been broken, sir. To get this unserved provisional attachment order, which has been sent to the bank, and there have been some form of communication wherein the bank refuses to allow us to look at what those orders are, number one. Number two, refuse then to unfreeze them. We didn't know what was going on for 6 months.
Okay, well, that's something we can come back to if I permit the application for immediate judgment to proceed.
Sure, sir.
So anything else on the reason for adjournment? Your essential reason for adjournment is that you wish to be represented by counsel who have some reluctance to register themselves as DIFC practitioners for reasons I don't really understand, but they wish to refile your defence, but we haven't seen the defence in draft that they wish to redraft. That's as I understand the position to be at the moment. Is that fair?
Well, sir, two different methodologies are being followed back in India and here, I suppose. There, once they take up the case, they take it up completely. Here, I have been asking them to take up the case midway.
Yes, I see.
Reluctant to do so because of their prestige, honor, or whatever. The first time they're coming into DIFC, they don't want to be on the other end of the stick.
I see.
So they are requesting a filing of defense again. That's all that is being requested. And if the court permits, within a week's time, we'll be applying for change of counsel. From myself, as self-represented, or whatever you want to call me, sir, McKinsey or whatever, and to the person in who's representing us in the High Court in Chennai, in Madras.
I understand. And when you say representing us in the High Court, who are us that they're representing?
The company and litigant 3 and 4, sir.
So
Defendant
when you say the
one,
company, which company do these lawyers act for?
they act for Mados Trading.
Okay.
The first defendant number 1, I believe. Defendant number 2, Mados Global FZE, as well as the Indian arm of Mados called Mados Infra Projects Private Limited. And number 3 and 4 in your list of defendants, sir, in DIFC, Mr. Sridhar and his wife Meenu.
Okay, and this is in different matters, yes?
This is the same matter, sir.
In the same matter, okay.
That's correct, sir. That is why we want to use him, sir.
I understand. And they're presumably being paid in India.
They are, sir.
So why can't they be paid in the DISC?
Well, sir, DIFC lawyers cost too much, sir. We can't afford
I see,
it.
the same lawyers will charge you more in the DIFC, will they?
Absolutely, sir. Hourly rates would be $600. I wish I had that kind of money, sir. I would rather pay the claimants, the outstanding, rather than pay lawyers for this. Just don't get me wrong. That's all.
Okay. Right. Anything else that you would like to say, Mr. Kamath?
Nothing else, sir. The rest of the submissions are where they are. It's with you. I'm hoping you've read them all. And
I have. You can rest assured that I have read everything. If you said everything you want to say on the question of adjournment, I'll give Mr. Temple a few minutes to respond.
I'll mute, sir.
Thank you. Mr. Temple, when you're ready.
Yes, Your Honour, you have my skeleton argument, so I think you know in broad terms what my position is on the adjournment. It may be worth, though, just picking up some points of detail from the Al Rehab case, which is in the bundle.
Yes, I've read Al Rehab.
There's at paragraph 45. I raise a specific point because it's so similar to what we've just heard. Page L6.
Let me go to that. L6.
Yes. Page L6, paragraph 45.
Okay, I have it. Thank you.
Well, I won't read it out loud.
Okay, well, let me just read it.
But you'd like me to.
No. I'll read it to myself, thank you, and just highlight it as well. Let's highlight it. Okay. Yes, I've read it. Thank you.
Yeah. Well, obviously, it almost exactly what we've heard this morning. The idea that they had spoken to some lawyers, but they were not yet DISC registered. And similarly to this case, as you know, if you've read the other paragraphs I referred to, in Al Rehab, there was no suggestion of what the defence would look like, which is, again, where we are in the case today. Then moving on, it may be easiest to do it from my skeleton argument, particularly if you've already read the specific paragraphs. The degree of, we would emphasise the degree of caution or scepticism that should be taken to a last-minute application. And I think in our case, it's even stronger than in the Al Rehab case, because I think there it was all quite last minute. It was quite short notice, I should say, that things occurred in Al Rehab about getting a foreclosure order. Whereas here we know that we've had at least, I think, 2 months since legal representatives were first on the scene. I think you referred to the 23rd of October. In fact, there's an even slightly earlier statement, which I think I didn't put in my skeleton argument, at page I8, in which, yes.
Forgive me, let me just. Okay, I have that. Yes, what do I see?
In paragraph 1 of that, saying in 2021, we couldn't get proper legal representation. This time, though, we have managed to get legal representations whose forms are being filed.
Sorry, you'll have to bear with me. I just.
Apologies. Page I8, I hope.
I have I8, and it's an email from Mr. Kamath dated 13th October. Is that right?
Yeah, it's at 9:08.
at 908. Yes, I have that.
Yes. So paragraph 1 indented.
Yes, it's presumptive. Yes.
Yes.
So where
that
are the
fourth
words you were
line
reading?
down.
Okay.
This
time, though, we have managed to get legal representations whose forms are being filed. You know what? It was my mistake when I said 23rd October. I meant this letter, 20. Forgive me. Yes, I meant 13th, not 23rd. Thank you for correcting.
So we have 2 months in which lawyers have apparently been engaged, and in which no draft defence has been produced. Although we're told here that forms are being filed. I don't know which, if they, well, we're told today those aren't the forms with the DIFC court. But in any event, it goes to show that there is no reason why the immediate judgment application should be derailed. If there was a real defence, there was plenty of time to get that filed with an application for permission to rely upon it. In a sense, the question of registration with the DIFC is arguable in the sense that the text of any defence could be drafted, whether or not the signature could be appended. And in any event, I would have thought, and you can correct me if I'm wrong, Your Honour, that the court would at least pay note of a pending application for registration if there was a counsel signature on the bottom of the defence, even though they weren't yet registered.
I think there's actually provision for emergency registration, but that's perhaps not relevant.
And on top of that, as you see from these emails around early October, the suggestion is not that they need time for defence, but that they're going to apply to the immediate judgment application. That's evident on this email we're looking at, and it continues as a theme. So the initial position was not that they needed a new defence, but that they could respond and would respond to the immediate judgment application.
Yes. Okay.
And I'm afraid that does also add to the impression one gets that this is late in the day in order to derail immediate judgment rather than as a genuine attempt to refile a defence. If there were genuine defences, then they could have been put in by way of reply to the immediate judgment along with a defence, and of course they would have been very relevant. In summary judgment applications or immediate judgment applications, it is quite common to realise that there may be a defect in a pleading and to produce the amended pleading as an answer to the immediate judgment application. And as you've read Al Rehab, you'll know that the Court of Appeal was supportive of the approach taken by the judge at first instance in that case.
Yes, you needn't. I mean, you needn't take me through. I've read that. Is there anything else that you'd like to raise?
Unless there's anything of concern to you, Your Honour, which I haven't addressed orally, then those.
No, I don't think so. Mr. Kamath, you have the right to respond to what Mr. Temple has said. Is there anything that you wish to add?
Yes, Your Honour. One of the things about he's mentioned the Al Rehab case as well. I could not find it here on his brief.
The Al Rehab case is at section L of the e-bundle, item 1.
CFI, what number is this, Mr.?
Well, do you have access to the e-bundle that has been filed in this case?
From case line, I'm trying to get in, sir, but I just couldn't get in.
Okay, well, in that case, the case is 2020 DIFC CA 006, 5th April 2021.
006 DI 2020.
Yes.
DIFC. CA 006, yeah?
Yeah.
I'll rehab real estate.
Yes. So what would you like to tell me?
The full thing isn't coming out here, sir, but I'll go with Mr. Temple's assessment that there is a case here which talks about the fact that it was about a foreclosure notice. In our case, that is not the case. It wasn't last minute, sir. As per what is written, what I've heard from you, because it's, even on DIFC, there's only 3 lines here that it's being ordered, whatever, no order to cost or whatever. But the full case history isn't coming here out. Which, anyways.
If it would assist, I can post a link to the chat function of the whole case, if that's easiest.
Yeah, if you can, please.
Mr. Kamath, we seem to have lost your video, by the way.
Yes, sir. He has. I've opened up the link. That's why I believe.
Okay.
If you can allow me the leave, sir, 5 minutes.
You do have a look at it. Yes, we can't have people citing cases you haven't seen. Yes. How are we doing, Mr. Kamath?
I am getting there, sir. I'm
Okay.
just at point number 37. It's quite a big case.
It is indeed. Well, no, I want you to have the opportunity to look at it.
Mr. Temple, can I ask you a simple question, sir? Is that possible for me to address Mr. Temple directly on this one?
No. You can
No.
you address
Okay.
you
Sir.
do it through me. That's okay.
Right, sir. Point is the points that he's trying to make. Is that point number 37 and 38, sir?
Okay. Well, let's have a look at that, shall we? I've lost my case line. So at paragraphs 37 and 38.
Is that what Mr. Temple was referring to? Is the question, sir?
No, he was referring to. Let me take you to the relevant parts of it, if I may. Look at paragraph 45.
Right, sir.
So Mr. Temple says that is similar to the present situation.
Right, so can I have your leave to read it properly, sir? 45.
You read that, and then I'm going to take you to some other parts of
Sure.
the judgment.
So while I'm reading that, sir, please have a look at 37 and 38 as well. I think this is relevant to what Mr. Temple was saying. Hence, I asked.
I will certainly do that while you're reading that 37 and 38. Okay, have you had time to look at 45? I've looked at 37, 38.
Yes, sir. We have a look.
Okay, now would you please go virtually towards the end? Let's see if we can get to paragraphs 120. So would you then please have a look at paragraphs 123
Sure, sir.
all the way through to 127. Just read
Sure,
those, please.
Sure.
Okay, have you done that?
I am on 127, so just give me half a minute.
Okay.
Please. Yes, sir. I'd like to. Sorry, I'm coming back on. Yes, sir. I've read 123 to 127. No, sir. This doesn't apply to us. To be very frank.
Okay.
It does not apply to us, sir. 30. Firstly, I'd like to go to 37 and 38. I think I mentioned to you.
Yeah,
we
sure.
haven't done this. We haven't done this last minute, sir. We have not gone AWOL on the claimants. That pretty much the Al Rehab case is like they've gone AWOL on the claimants, not responding to them, not keeping them abreast of things, saying that they've got other things to do. We have done none of that, sir.
Okay.
When the claim was served, we accepted the service despite our hands being tied at the back with no representation. We still got a defense filing in, which I felt was I shouldn't have been doing it. Number one. Number two, sir, from 123 to 127, it talks about the fact that the defense was never filed. It was filed, sir. It wasn't last minute like it is Ramadan now and 3 days back I'm filing for adjournment. I have filed on the 29th, sir. To every the right way I've filed it. I've asked queries to DIFC registry saying that do I need to file for all 5 defendants or one is enough? Al Rehab, sir, does not apply here, sir. It is about a defendant who's gone literally AWOL on communication. We haven't done that, sir. We have filed a defense. All I'm asking is to refile it properly.
Okay, thank you very much. Is there anything else you'd like to add?
That's it, sir. Thank you.
Thank you very much indeed. Well, look, Mr. Kamath, I'm afraid I'm not going to adjourn the application for immediate judgment. Not because I haven't listened to what you've said, but because of this reason. I'll give my detailed reasons in writing later in this week, but this is the fundamental reason why I'm not going to adjourn. In order to get an adjournment, you have to show that there is, I would say, a realistic defense. But on the other hand, if you have to show there's a realistic defense, you will win the immediate judgment application. So when you're talking about adjourning an immediate judgment application, it's the same test, it seems to me. I'll explain why in my written reasons why I think it's the same test. So I'm not at the moment simply saying the situation is the same as Al Rehab. I will look at the evidence that you've taken me to, and I will reach a decision on that. But the main reason is that there's this overlap. So that if you show me a real defense, you would have been entitled to an adjournment, but you win the immediate judgment application anyway, and you get a chance to refile your defense. So the two have that overlap, and it seems to me, therefore, that the most efficient way forward is that I hear the application for immediate judgment and then decide on what you tell me whether I think there is a realistic defense. And if there is, the immediate judgment application goes away entirely. It's not adjourned. And you get a chance to put a defense in. So that's why I'm not going to adjourn it. Instead, I'm going to go straight ahead and invite Mr. Temple to make the application. I had said in my directions that he's going to have an hour and a quarter on that. I think he's on London time. That will take him to 10:30. London time. I make it 9:15 now. You will then have the opportunity to respond, and you get an hour and a half. So you will be till 12 o'clock English time, or that will be 4 p.m. Dubai time, and then Mr. Temple has a short response. We might take a break between those just to see how we're getting on, and if people want to take a comfort break or something. But we will start now with the next hour and a quarter, if he chooses to use it, with Mr. Temple making the application for the immediate judgment. Mr. Kemath, you wanted to say something?
Yes, sir. I have filed a defense last year, and there's a whole heap of stuff that has been delivered over the past 2-3 weeks. I can rely on all of that, can't I, sir?
You can rely. I have. Not only can you rely on it, of course you can rely on it, and not only that, but I've read it too. So you can rely on anything that you have put before the court at any time since November of 2021. Okay, but it's Mr. Temple's turn now. As I said, he's got an hour and a quarter to make good his application for immediate judgment.
Thank you, Your Honour. In terms of timing, I'm very aware that, given the lack of any response which specifically deals with the immediate judgment and the lack of a skeleton, I'm really primarily engaging with the defence as it was filed. I don't know whether from those more recent comments from Mr. Kamath, he wants to suggest that some of the arguments about a breach of the exclusive jurisdiction clause give rise to some defence. The alleged.
I think you have to take it that he does. If it's helpful to your submission. Sorry, let me just bear with me 1 second. I've identified really the areas where I think taking not only the defence but also the recent correspondent that the defendants raised defences, and I think there are 8 actually. First of all, and I think some of these you've dealt with and some you haven't yet because they arose out of more recent correspondence. But number 1, that there were delays in dispersing the loan monies that adversely affected the joint venture. Number 2, that the facility agreement is subject to a framework agreement that was never executed and so is therefore unenforceable. Number 3, there was no meeting of minds with regard to the facility agreement. Number 4, by executing the freezing order or provisional attachment order from the Abu Dhabi court and by initiating proceedings in the Indian courts, the claimants are in breach of the jurisdiction clause in the facility agreement. Number 5, the claimants fraudulently misled, misrepresented, and concealed information that, having not filed a case in a competent UAE onshore court within 8 days, the attachment order had no effect. And the claimants therefore fraudulently caused the defendants financial loss and impaired their ability to settle the debt. 6, the late disbursement of facilities, the once in 100-year monsoon flooding of the mining works, and the impact of COVID-19 should be treated as disruption events within the meaning of the facility agreement. And 7, more broadly, the facility is intertwined with the joint venture agreement. And finally, so far as the guarantees are concerned, they also make reference to the framework agreement, which was never executed, and are also subject to the disruption events. So that's what I have identified as the various defences that have been raised. I think they're the same as those in your skeleton, but with the addition of those that arise out of the second witness statement of Mr. Kamath, to which your instructing solicitor responded yesterday in his 4th witness statement.
Yes, that's very helpful, Your Honour, and I'll try and make sure I address all of them, although, as you say, some of them are in the skeleton argument, and if I take some of them at a higher level, I hope the written submissions make the case for us. Equally, if there's anything...
Can I just pause there, Mr. Temple? I'm so sorry. Mr. Kamath, I think you heard the list of what I had taken from your submissions as the heads of defence. Do you consider that to be a fair summary of the way you've put your case so far?
I do, sir. There might be additions that I'll make.
Yes.
Not additions, but within those frames.
Oh, you
of
can expand.
issues.
You can expand on those. Those are just
Sure.
the headline summaries that I had taken. So you can see that I have read what you've said, everything.
Thanks. I was a bit worried. Sorry.
Okay. Thank you, Mr. Temple.
You can proceed, sir.
Thank you.
Well, given what you've said, Your Honour, about having read the documents in some detail, I won't go through all of the clauses in the various contracts, but I think it's still worth starting with the facility agreement in G1.
Okay, let me go to that. Yep.
And so obviously you've got the front page there, and then on G2 the substance of the agreement starts. One point to note initially is that the way the facility agreement is framed is that Mados and the SPV, as they're defined, i.e. the first and second defendants, are collectively referred to as the borrowers. So this was a joint obligation between the two, and that may make some sense of the fact that there were then separate corporate guarantees individually, which may not make a great deal of difference in the end if you agree that they are liable as borrowers. But that's just to explain what's happening there. The next port of call is recital B.
Mm-hmm.
In which it said that the lender has agreed to provide $11 million to the borrowers subject to the terms of the framework agreement, which is simultaneously being executed along with this facility agreement. So this is item 2, I think, on your list of 8 that I'm going to address by reference to this. And we can see also in recitals D, F, I, and J, I think, references to the framework agreement, though it doesn't then reappear within the clauses, the numbered clauses of the contract. Now, that in and of itself,
the framework agreement does reappear in the numbered clauses of the contract. There's reference in 1.1.
Well, apologies then.
I can give you all of the references if you like.
Well, it may be that my search terms. You're quite right, Your Honour. I thought they reappeared in the guarantee, but not in the. But you are quite right.
Recital B, recital D and I, J, clause 1.1, clause 3.1.4.
Yes.
And the signature clause actually refers to the facility agreement as the framework agreement.
Yes, well, my search seems to be working better now, and I can see all of those. And I hadn't frankly noticed the oddity about referring to the facility agreement as the framework agreement.
Yes. This is not the most professionally right, although it uses all the words. It doesn't necessarily use them in the right order.
Yes, you're right. What's obvious from these recitals is that there was an intention to agree a framework agreement. It says explicitly in recital B that was the intention, really, that it be simultaneously be executed. Now, whether this is the use of boilerplate or whether it was a very specific intention at the start of drafting that there be a particular framework agreement, I don't know. But it is common ground that the defendants were never provided with any framework agreement.
Yes.
They never signed one, they didn't execute it. And it may, apart from boilerplate, it may be that the need for expedition at the time of signing led to the framework agreement being put to one side. But whatever the basis for it being put to one side, there is no executed facility agreement. So the question the court has to grapple with is what to do where a contract refers to some other agreement which was never agreed. And we say that plainly there's only one answer, which is the court has to deal with what was actually agreed. and not with some further contract that might have been agreed but was not. There is, I think, somewhere in the email some suggestion that a draft was prepared at a point, but there's no suggestion that defendants had any input into what it might contain. And there's no suggestion in the defence or the response to this application that they had requested that any particular clauses go into a framework agreement. It's the opposite of that. They really say that they never saw it, and they never agreed it. So the short point is that where all the key parts of a loan are agreed and nothing further was agreed, then that is what the court has to deal with what is in the facility agreement. It's axiomatic that the contract is made up of what was offered and what was accepted. And here, the Mados companies accepted the terms of the facility agreement, but nothing further. In the specific DIFC context, the law of contract asks what the intentions of the parties were, and that intention cannot be found in further documents that were never discussed. There is a slightly broader ability to look beyond the four walls of the contract, according to the law of contract, about what happened before and what happened afterwards. But the key question is what was the intention of the parties? What was agreed? So we say that a reference to a framework agreement that simply was not agreed can't affect the interpretation of the facility agreement. So that's our response on defence number 2.
Well, can I just raise another issue, which I'd like to understand, and Mr. Kamath can have a think about this while you're doing other issues, but where does the point go? Because if this agreement is unenforceable because it's lacking a specific term, or it's lacking supplementary provisions that the agreement needs to be effective, and so as a document it doesn't work, where does that leave us? Because it's admitted that it's been a loan, and it's been indeed admitted that the loan carries interest. And so then aren't we just left with a simple contract of loan, payable, repayable on demand?
Well, Your Honour, I would resist that as a conclusion.
You would?
In
Why?
part,
It's in your favour.
I can see it might be on the face of the facility agreement itself, but when one gets into the guarantees, you can see that there might be more other arguments that, frankly, I haven't thought through at this moment in time. And the reason I'd resist it is as a matter of law, that there is nothing lacking from this agreement. There is no key term required to make this agreement work. And if there's one thing at the heart of the law of contract, whether it be DIFC or English law, it is the desire to give effect to the stated intentions of the parties. Freedom to agree whatever the parties wish to agree within, obviously, certain limits. And here, everything that one needs for a facility has been agreed. It is not as though there is some lacuna which the framework agreement could be expected to fill. There's no suggestion of any lacuna at all. And I would have to go back into case law, at least of English case law, as to the approach to be taken, but to give you any dicta to this effect. But I would say that it's at the heart of contract law that you give effect to what has been agreed.
Okay, well, I have your submission.
Yes.
It doesn't gain by repetition. We've got.
No, you're quite right.
Okay.
So going back to the facility agreement, I was touched on the disruption event, I think is the next thing if we're turning the pages. It's page G6 at the bottom. It's quite a long definition of disruption event, and you've no doubt already read it.
Yes.
the short point here is that it's clear that for something to be a disruption event, it must
has to disrupt the payment mechanism, not the underlying contract.
Exactly. Yes, Your Honour, you have my point there. And a monsoon or COVID, or even a late disbursement, certainly if it's post-contract, wouldn't fit within. The late disbursement seem to be split into pre-contractual late disbursement and possibly an argument about post-contractual late disbursement, but neither of them work. I'll come back to those in due course.
Oh, yes.
So again, on a page turn, as it were, I won't. Maybe it's just worth noting that clause 3.3 is the 18-month tenor. Clause 7.1 is the repayment provision. It might be worth just looking at that briefly on page G19.
Okay, bear with me a second so I get there. Okay, I have it.
And the reason for pausing on that is because there's some words in parentheses after the main text of clause 7.1. saying, as discussed and confirmed with Raj, the same can be confirmed 9 days after all equipment's reaching site to firm up repayment schedule without penalty of 2%.
Yes.
And this is relevant to, I think it may be item 3 on your list, the no meeting of minds point. Because as I understand it, that is reliant upon an email in which there was some debate about some amendments, and at least one of them seems to be ticked off by this amendment.
Yes, there was a pre-contractual email which I was seeing. There were responses in red.
Yes.
To it. And that's the email you're thinking of, are you?
Yes, it's C20. Ooh, I think I may have just got the wrong. It's E198, I think.
E198. Do you want to go to that?
Well, we may as well at this point, I suppose. It's okay. Because insofar as it is suggested that there's no meeting of minds.
Yeah.
My primary. So Mr. Kamath has got his hands up.
Mr. Kamath, yes. It's not usual to interrupt counsel in the middle of their submissions, but.
Sorry, sir. I can't get into the case lines here, so I'm not so sure where this E20, etc. is. Sorry.
You've been sent a link to case lines. Why can't?
I just can't get through to it, sir. Hence, I interrupted. I didn't mean to. I don't know what you're referring to. Hence the problem.
Well, when we get there, we'll tell you what it is, and you'll probably have access to it in a different way. So let's go. Yes, okay. So, sorry, Mr. Temple, take me to that email, and then we'll tell Mr. Kamath what it is, and you can find the original. It's his document, actually.
Yes, it is. So, Mr. Kamath's reference, this is Exhibit 12 to the defence. An email chain of the which I think ends on the 8th of March.
Yes.
Page E201, at the bottom of that page, E201 is where we get the red.
Yes, so Mr. Kamath, this is your own document that you exhibited at Exhibit 12 to your defence. And it's an email exchange. And the one with the red writing that I was thinking of is the email of the 8th of March of 2019.
And the reason I mention it at this point is because just over the page at E202, at the top of the page, there's a reference to 7.1, being the repayment schedule.
Yes, that's the second part of the email that we're talking about, Mr. Kamath.
And there's a reference to we don't want to pay I think this is Mr. Kamath saying we don't want to pay the 2% penalty here, having agreed to this repayment schedule and then changing it.
Correct.
And Mados, who is from the claimant says, as discussed, once final DD commenced, we will adjust accordingly. So there was a discussion around 7.1.
That feeds back into the agreement, which is at G19 again.
Yes.
Paragraph 7.1 of the agreement. Okay.
Yeah, so it's really to show that this email was not something that was kind of put to one side. If there were differences between the email and what's in the contract, well, that's just a fact of they agreed what they finally agreed. But here, at least for 7.1, it made its way into the agreement.
Yes.
There's no suggestion, there's no evidence that any change to the repayment schedule was agreed. Apology, I'm just noticing from those.
Yes, I'm just responding, saying please do, basically.
Right. Yes, that would be helpful, and I thank those instructing me for doing that. So yeah, so there's a reference here, as confirmed with RISE, the same can be confirmed after equipment's reaching site, that should be SITE, I'm sure, to firm up repayment schedule. In the end,
your principal argument is that that exhibit to the defence is contractual correspondence, and it's superseded by the executed agreement.
Yes, on this one point, in case it was argued against me that it was said we will change it and then it wasn't changed.
But it's there.
It's there. In 7.2, there's also its relevance to the interest calculation. We can see that if in the event that part of the loan was fully repaid after 18 months, not fully repaid, it can be extended for a maximum of 6 months upon a request in writing. And this shall be subject to the increased interest as stipulated in 9.1.3, which you may recall is the highest rate of interest at 20.5%.
Yes.
The reason for noting that is because Mr. Kamath seems to suggest that the fact that the claimants extended the repayment date is indicative of us accepting that COVID or the monsoons were disruption events. And he says, well, why were you changing the date if you weren't treating them as relevant disruption events? Well, we'll see why it doesn't, and I'm sure you've gathered why it doesn't work as a disruption event. But in any event, we can see here why it was extended, because it was provided for in the contract, subject to payment of increased interest. So I think that may be part of the disruption event defence.
Yes.
At clause 22, page G44.
If we're doing a page turner,
yes.
Can we just address the argument about late disbursement? And actually, you go back to clause 6, and clause 6 talks about drawdown amounts and schedule. So 6.1.1 through to 6.1.4, as I understand it, define the drawdown dates as the actual disbursement dates of the, if you like, pre-agreement payments, the payments that were made pursuant to the 10th of December agreement. And so if it is agreed that the actual dates of disbursement are the contractual drawdown dates, and this agreement supersedes the 10th December date, at the moment I have some difficulty in understanding how there could be a claim for breach of contract. I have to say I don't accept your submission, subject to you persuading me otherwise, that the fact that they were paid pursuant to the earlier agreement is irrelevant to the facility agreement, something you say in your skeleton. I don't accept that, because the facility agreement supersedes and sucks in essentially the earlier agreement. But what it does appear to me, again, subject to what you and Mr. Kamat say, is that once the early agreement is sucked into the facility agreement, if the actual date of drawdown is the scheduled date, then there can't be logically a breach of contract for payment on that date.
Yes, Your Honour. I would agree with all of those points, and also 6.1.5 and 6.1.6 make it clear that later drawdown dates are
at the discretion of the lender.
Quite. I mean, in terms of the earlier contract, I think it was possibly in the witness statement of Mr. Sharrock rather than my skeleton argument, but we also make the point that it is not binding, that it's indicative itself. But in a sense, this supersedes all those arguments. And
yes.
I would agree that clause 6 deals with, well, I guess that's items 1 and 6 on your list, if as I've got it written down. But yes, I have nothing to add to clause 6 on that.
Okay.
Where was I? We can see it. Clause 9 is the interest. I won't go through that unless there's anything. So any questions you have on that. But G44 is of some relevance.
Okay, just go there. Right. Yeah.
Clause 22.1. We have here the no set off. And this goes to any argument that there was a breach of this contract by virtue of the alleged breach of the exclusive jurisdiction clause.
Yes.
Because it would not provide a defence to the immediate obligation to pay, even if there was any merit in it. And I will look in due course as to why we say there's no merit in it.
But your case is that if there were any merit in it, there's nothing to stop the defendant bringing a claim against your clients for breach, for damages for breach, but they've still got to pay the agreement.
Yes, that's precisely the point.
Okay.
And so, although we didn't do a full page turn there, those are clauses which I think are particularly pertinent. My skeleton argument refers to other elements which I think will address the other points, or at least many of them, at paragraph 26. So paragraph 26.3, I have the no meeting of minds point, referring to exhibit 12. We've already addressed that. Yeah. Pre-contractual negotiations, which are overtaken by a signed document, and the signed document should be given effect to. Moreover, it is not at all realistic to suggest that this signed document somehow gets ripped up by reference to some marginal argument about some aspect in that email. And the reason I say that is because it is not suggested by Mr. Kamat, as far as I can see, that there's anything in that email that is pertinent to the immediate judgment application. It is not suggested that there's anything in that email which allows an extension of time by reference to delays on the project, or by reference to some broader definition of disruption event. And so, you know, any element of debate about some of those requests don't take us anywhere unless Mr. Kamat can explain what difference they make. As I say that, I realise that one of the points I didn't take you to in the agreement is the reference to disruption events as it applies. I won't go back to it unless you need me to, because I think you'll have seen it in the submissions. It's in clause 17. Disruption events are relevant to an event of default, but they only give an additional 3 days for payment, even if they applied.
Okay.
Paragraph 26.4 of my skeleton argument addresses something from the defence, which I'm not sure was within your list of 8, Your Honour,
Okay,
but is possibly an additional one. The suggestion that there was a rollover of a facility agreement by reference to an email in which Mr. Kamas said, well, we'll accept a rollover if you do X or Y or Z.
No, you're right. That's not something I'd got to in my reading.
So that's page E231, and it may be worth just
dealing with it. I've got it at K9, your skeleton.
Yes, sorry, the skeleton argument would be K9.
Yeah.
The email to which I refer is page
E231. Yeah, okay, let me go to that. Mr. K. Matthews.
This email, which from my defense exhibit are we talking about, sir?
This one is exhibit 12. Sorry to interrupt you, Honor.
Exhibit 12, yeah?
Yeah.
We're still on exhibit 12. Okay, thank you.
It's yes, and it's an email dated the 8th of June of 2020.
Apologies, then apologies. That's my mistake in the skeleton argument. I'm misreading it. It's exhibit. Where's it gone?
E231. Let's have a look.
Exhibit 20. Apologies.
Defense exhibit 20. Thank you. Let's do carry on. So email dated the 8th of June.
8th of June. In the defence, it suggested that a rollover was agreed, and that's why I raise it. You can see here that, in fact, nothing is agreed. 2 options are put forward. One is a willingness to accept the term sheet with additional funding of 2.5 to 3.5 million USD. And option 2, if option 1 is a no-go, willing to accept an extension, but we request a waiver of a fee and we request reduction in interest rates.
Right, sorry, let me just get the highlighter on that. Willing to accept additional funding, option 2, extension of tenor. Yeah, okay.
So, as I say in my skeleton argument, well, clearly it's clear from this that refinancing wasn't in fact agreed. Both of these are counter offers to an agreement, and of course both would then conflict with the fact that the payment deed was subsequently agreed, which was on a completely different basis.
Yes. Yep.
At paragraph 26.6, I then deal with the disruption events, but I've already commented upon that.
Yes.
And paragraph 26.7 is, I think it's item 7 on your list of defences, about it being tied in with Eastern Coalfields Limited contract, which it said it was delayed. There is reference to the ECL project contract as a condition precedent to a drawdown, but there's no reference to that in reference to repayment dates or extensions of time. And of course, one wouldn't expect to see anything like that in a facility agreement, where the bank or where the claimants are lending money. It's for the defendants to make use of that money and to make arrangements for repayment. So I think that deals between my submissions and our brief introduction on clause 6 that it deals with most of the list that existed at the date of the skeleton argument, apart from the guarantees, which I'll move on to and deal with separately. But we do have the question of the exclusive jurisdiction clause.
Yes.
Apologies, I possibly should have gone to that whilst we were looking at the facility agreement. It's clause 31.5 on page G52.
Yes.
And so we have here, first of all, if the parties are not resolved within the mediation window, such matter in dispute should be referred to DIFC courts, agree to submit to the exclusive jurisdiction of DIFC courts, and any decision passed by the DIFC is deemed final and binding on the parties. So that is, on its face, an exclusive jurisdiction clause, but it is subject then to 31.6, which says that lender and or the security agent, as the case may be, may, however, bring proceedings in connection with the facility agreement, including their existence in any court of competent jurisdiction, and to the extent allowed by law, take concurrent proceedings in any number of jurisdictions. So we would say that it is not an absolute exclusive jurisdiction clause in any event, because it is clear by 31.6, by the use of the word however, that it is a carve out from the more general exclusivity, and that it is open to the claimants to take proceedings in other jurisdictions.
It's not the most elegant drafting, is it?
No, it isn't. But it is clear in my submission that it is a carve out. It is an asymmetric jurisdiction clause of the type normally seen in facility agreements, even if it's not drafted as well as it might be. But in any event, the action taken to obtain security in Abu Dhabi is not a breach of an exclusive, even an exclusive jurisdiction clause, and we rely in that context on well, that we put into evidence a page from Dicey, Morris and Collins on conflict of laws, which sets out the general rule, or the generally accepted rule, that, and this is page 8220, that in the absence of clear wording, a jurisdiction clause will not be interpreted to preclude applications brought solely for the purpose of obtaining security in some other forum.
Yes.
And we also cite an English case that really just repeats that general rule and refers back to some earlier cases. So the Abu Dhabi attachment is consistent with that exception to the rule. And of course, it's not at all unusual for security to be obtained elsewhere. And any construction of this jurisdiction clause which suggests that we might be in breach would be really quite troubling, because it would mean that a lender would be unable to seek security in such jurisdictions as security might be available. And of course, that's one of the protections that a lender expects to have.
Yes, actually, the point was considered by the DIFC Court of Appeal last week or the week before last, I think.
I did look at that. Yes, asymmetric clauses were. That was a slightly different question as to whether the bank had committed to the DIFC by the particular form of asymmetric jurisdiction clause.
Yes,
but
I think I suspect very strongly that it was Sir Peter Gross who authored the judgment of the court, and it was said that these are quite familiar clauses and should be given effect according to their construction, which is probably a truism. So the question is whether on its construction this is an asymmetric clause.
Yes, as I say, I think it's in slightly different terms, actually, because the case that it is Calgary and Mashrek Bank.
Yes.
And certainly the panel included Justice Sir Peter Gross. But yes, that was one where the bank hadn't committed to the DIFC, so it hadn't submitted to the jurisdiction. It doesn't really. I'm not sure the same would arise out of this contract, but in any event, it's not the question in issue.
No, I think one draws from that case simply that the court is familiar with asymmetric clauses being in a banking free zone and will give effect to them if the court considers that they are valid clauses.
Yeah, so that's quite right, and in that particular case, notwithstanding some sympathy, I think, but
yes,
here really there isn't any question of sympathy in my submission, because what's happening in Abu Dhabi or what happened in Abu Dhabi was an obtaining of security under the laws of Abu Dhabi. And obviously it's not for this court to question, potentially subject to the fraud point, which I'll come on to, but the broad question of whether Abu Dhabi was right to issue an attachment order isn't for this court.
No, I mean, as far as I'm aware, UAE attachment orders don't have undertakings and damages in the same way that obviously a common law freezing order does have. But on the other hand, there is the concept of abuse of right if a party under the UAE Civil Code, if a party considers that a right has been used oppressively by its counterparty, then it does have the ability to make a claim, which may, I'm no expert on UAE law, but may give rise to remedy. I don't know, but it's certainly outside my jurisdiction.
So that's the question of the exclusive jurisdiction clause and whether there's a breach of it.
Yeah.
There's a separate question as to whether a fraud was committed by the claimant by not issuing its own, by not issuing substantive proceedings in Abu Dhabi within 8 days. Yeah. Which of course, I think directly contradicts the argument that there's a breach of the exclusive jurisdiction clause, in the sense that it seems to argue that we should have pursued a substantive claim in Abu Dhabi, notwithstanding the exclusive jurisdiction clause. But this is all addressed in Mr. Sharratt's fourth witness statement, including setting out some of the relevant law, which suggests that if a lawsuit was previously filed, then that is adequate. And the relevant lawsuit is a lawsuit before the competent court. And certainly, as Mr. Sharratt sets out, the competent court here is the DIFC, or is at least capable of being a DIFC court, and that the Abu Dhabi court required us to provide evidence of these very proceedings in order to satisfy the requirement that substantive proceedings be issued within 8 days, or in this case, predating the attachment order. So there's really nothing in the point. But if there was something in the point, then A, we've got the set-off clause, and B, the natural forum for that kind of dispute, one would have thought, would be the Abu Dhabi court, because it'd be saying that there was a problem with what we said to the Abu Dhabi court or what we said to the bank. Now, we don't accept for a moment that there's anything wrong with it, but it does not provide any reason for the corporate defendants not to repay the monies it has borrowed and has not repaid under the facility agreement.
Okay.
I should say it was noted in your list, Your Honour, a reference to Indian litigation, and I may have missed it, but I didn't notice that being raised before today. It was obviously something that Mr. Kamath mentioned.
No, it
during
was. I clearly picked it up from my reading,
Right.
and what I read was, in fact, a cut and paste from, I think, the second witness statement.
Right. Well, I have to say that had escaped me.
But we do know from what Mr. Kamath said earlier that there are apparently enforcement proceedings in India, and that that counsel are instructed there.
Well, yes, I don't know that they are enforcement proceedings. I think there was reference to proceedings, but it may be.
No, I asked him
what he said
earlier today. I said, and he said they're the same proceedings, which is why it's the same parties.
Well, I'm in some. I've sought instructions on that. I can say.
Well, Mr. Kamath may have been confused, but yes, I mean, you can seek instructions while Mr. Kamath is addressing me and deal with it in your reply.
Obviously, we've already looked at the ability for us to pursue concurrent proceedings in any event, and that's
it falls under the same the same rubric in the list of defences, certainly.
Yes. And then the only thing left is, I think, from your list of defences, the question of the guarantee, which, as you mentioned, seems to largely rely upon the same arguments about the framework agreement and the disruption events.
Yes.
It is probably of primary interest in relation to the personal guarantees, because, as I say, the corporate defendants are, we would say, liable under the facility agreement in any event, in addition to having guaranteed each other under the corporate guarantees. And so if one turns to the guarantee that Mr. Kamath made, and that's from page G121.
Yep.
Paragraph 3.4. There are all the guarantees that that are referred to in the defence and sorry, in the particulars of claim, and I'm sure you've looked at. But clause 3.4 refers to any amount that would otherwise be claimed by the lender or the lender through the security agent, if it's for any reason not recoverable thereunder. It does say, on the basis of this personal guarantee, the guarantor shall act as a principal debtor and primary obliger and indemnify the lender and the security agent immediately on demand against any cost, loss, or liability which the lender or the security agent might incur or suffer as a result of another obliger, defined to include the borrowers, not paying any amount when it would have been due under or in connection with any transaction or document. So the reason for raising this is that even if there's some problem with the facility agreement, clause 3.4 addresses the problem from the perspective of the guarantee by saying that the personal guarantors will in any event make good the loss that we suffer by reason of not being able to recover it. So it may go back in a way, in a roundabout way, Your Honour, to your suggestion that there might be a simple contract, because it all goes back to the heart of the matter, which is that $11 million were lent and have not been repaid. So we would say that even if there's a problem under the facility agreement, 3.4 bites, and later on in this contract at 9.3, it also refers to any amount which is not paid shall bear interest at the default interest rate.
Sorry, where are you reading from?
Sorry, this is page G134.
G134.
So if there's a problem with a facility letter, it says here, well, it says that the sums to be paid by the guarantor shall attract a default interest rate.
Yeah, clause 9.3. Okay.
9.3, and the default interest rate is defined at the top of the personal guarantee by reference to clause 9 of the facility agreement.
It's the 20.5, isn't it?
We would say it is. It's defined in the actual guarantee as the rate of interest as determined under clause 9 in the facility agreement.
Yes, I have that.
So that's the 3 layers of interest at different times.
Yes.
So unless there's anything further on the guarantee, I've certainly addressed the 2 points I think you mentioned, being the facility, the framework agreement and the disruption events. Plainly, on any reading of these guarantees, they are intended to fight on the non-payment by the corporate defendants.
Yes. So is that everything?
Well, Your Honour, I've got something to say on interest, and I don't know whether you prefer me to do that now.
No, I was going to. I was. Well, actually, 2 things. I mean, whilst clearly I have not come to any final decision, given that you've done very well on time, and so what I'm going to do is give Mr. Kamath a bit of a break now so that he can gather his thoughts and respond to you. But I think he should have the opportunity to respond to everything in one go, rather than doing it in a bitty way. So I'd be very interested to know what you say about interest and current and the current amount of the debt, and indeed, probably, whilst it may be unnecessary and premature, you might just tell me something about your schedule of costs as well. So Mr. Kamath has the opportunity to deal with everything. As I say, given that we have the luxury of a bit of time, I might give him 15 or 20 minutes just to gather his thoughts and look at what you said. So could you please address what you want to say about interest, and if you've got an up-to-date calculation so that Mr. Kamath can see that would be helpful.
Yes. So my skeleton argument talks about this from paragraph 40, but I'm afraid it's got 2 errors in it, which I need to correct.
Okay. Well, let me go to your skeleton argument. Yeah. Okay, paragraph 40.
So the original draft order sought the capital sum plus interest at 20.5% from the 5th of September. But as I explained in 41, it is a bit more complicated because there's interest both before the 5th of September and afterwards at different rates.
Yeah.
The errors come in paragraph 41.3 of my skeleton argument, where I say when the final date of repayment was extended 4th of December, interest was chargeable at 17%. That's wrong, and as we look through in the clauses, it by reference to clause 9.1.3 and clause 7.2, interest was chargeable at 20.5% in that period, and so really that 20.5% applies from the 4th of December, but also then, sorry, applies up to the 4th of December and also after the 4th of December. And this, I think, is based on my misreading of an interest calculation that we'll look at in a minute. It doesn't actually change the numbers, but the explanation of how we get to the number was wrong. The second error is that in paragraph 44, I ask that we be allowed to replace paragraphs 2 and 3 of the draft order with the up-to-date calculation.
Yes.
And I say it's 19.026 million.
Yes.
As we'll see in a moment, that includes some fees some other costs and fees, which actually we've asked to be dealt with separately, of about $327,000.
Okay.
So the correct number, if you'd like to note it down, Your Honour, is 18 million.
Is that to today?
That's to today, yes.
Okay, 18.
699,000.
699.
144.
144.66.
0.66.
Excluding fees.
Yes, excluding fees.
Okay.
And I'll explain that by reference to page J1, which is an interest calculation done a few days ago, but updated to today's date.
Okay, so C calculation J1. Let's have a look. It's a bit unreadable.
Yes, I was slightly worried that this would happen. I downloaded it as a PDF and I found my PDF view is a lot better at zooming in than Case Lines is.
Yes. Okay, I can. Yeah, maybe I can zoom in on it.
The part of the page that we're particularly interested in is a table about 2/3 down, which says outstanding drawdowns.
Okay, yeah, it's not. Yeah, it's not zooming very well for me, but I do have a separate copy. I think, well, maybe not as up to date as this.
If you downloaded any version from Case Lines, it will be this version. We haven't updated page J1, I don't think.
Okay, all right. Well, bear with me. Well, I may only have your initial bundle, which may not be. Bear with me. I might be able to get the. Yeah, I'm not sure I've got it. And also, I'm a bit aware Mr. Kamath may not have the facility to do it. Could somebody be kind enough, or could you do it if you've actually downloaded the PDF? Would you email the PDF to Mr. Kamath and to me now? Can you do that?
Yes, I think so. So it's a single. I'll just provide you with this single page rather than try to send
Yes.
anything larger.
That's probably the quickest way of dealing with it.
Yes, so you're on which email address is best to send it to?
To me, would be michael.black@difccourts.ae.
michael.black@difccourts.ae. Yeah. Yes, and Mr. Kamath's email address I know I can find somewhere.
I think it starts with kamath.raj@madosglobal.net.
Yes, I've got that. Thank you.
I'll let you know when it's come through.
I've sent that, so hopefully it will emerge quite quickly.
Good. Might take a couple of minutes. Got it. dear, where's it gone? There we go.
Can't zoom, can we, this one?
It depends which PDF viewer you're using, I think. Certainly if it's in Adobe or any standalone viewer, you can normally zoom in.
Yes, I've zoomed in on it.
So the part of the table you're on and Mr. Kamath, if and when you can zoom in, is outstanding drawdowns about.
Let's just wait for Mr. Kamath. I don't want him to be prejudiced at all. Do you have it, Mr. Kamath?
I do, sir. I'm just trying to zoom in. It is so small that I just can't. And I'm just finding the buttons to do so.
Yeah, well, it's all there, and it's all there in the normal Adobe PDF. You can do that.
Something happening with my side here, but it's fine.
Okay, all right, Mr. Temple, carry on.
Yes, in this part of the table, outstanding drawdowns, you can see that it's split up by the installment date that was supposed to be paid.
Sorry, sorry, you'll have to.
So
bit more helpful.
Apologies. We saw earlier in the facility agreement the loan was to be repaid in installments at various monthly points during the facility agreement.
Yes, so I've got the disbursement tabs here.
So it should have tranche 1, tranche 2, tranche 3, tranche 4, tranche 5 on the left-hand side.
Tranche, I don't see. I see a heading, initial drawdowns and cash movements as of 15th March, and then disbursements on various dates.
Yes, the interest calculation that we align is further down the page.
Yes.
Under outstanding drawdowns.
I have that, yes.
Although it refers to drawdowns, I think this should really be repayment tranches.
Okay. And that sets out the interest calculation, does it?
It does. You have to go across the page bit by bit. It's split up into the different periods. First of all, you have original, about, what is it, 7 or 8 columns along. There's original maturity date.
Yeah, I have the whole thing on a wide screen, so I've got all that. Right. Okay, take me through it then.
So the original maturity date is by reference to the dates by which each instalment should have been repaid.
Yeah.
The second and third lines are the small amount of repayments that get deducted from that outstanding sum.
Yeah.
So in a sense, that they're giving credit for that. You can see that there's original maturity date, interest rate applied at 15%.
Yes.
Which is then applied to the original maturity date. Then there is a supplemental interest rate charged up until the 4th of September 20, which is the original end date. So that's for each instalment. Because each instalment wasn't repaid.
Yeah, total supplementary interest to 4 September. I see that. Yes.
And then we get 20.5%, which is applied from the 4th of September to the 4th of December.
So there is an additional supplement of 5.5%.
A total supplemental of
and then a total supplemental of 20.5.
Yes. Up until the 4th of December 2020.
Yeah.
And then a supplemental interest from revised maturity till snapshot date, and the snapshot date is today.
That's today, is it? Okay.
Which gives us 4.6 million for that additional period.
So that's today. Just need to know that.
Yes.
So annotate the. Annotate the PDF. Okay. Yeah. So that's today.
And
so that's where you got your 1906 from. Yeah, I see that.
Well, the mistake was that I got 19026 which includes the column for other fees.
Yeah, I see that too.
And so I should have deleted that because that's dealt with separately. There's a whole list of fees at the bottom of the page.
Other fees. Well, you got your 327. Yeah. Okay, I see that.
Which are, as I understand it, separate from the legal cost of this particular case. And you'll have seen from our draft order, we've asked that they be dealt with separately. In the scheme of things, they are not a huge amount compared with the capital and the interest, but we have we don't suggest they can be the subject of immediate judgment today.
You're not pursuing the fees today?
Well, the draft order that we have provided and would ask for is at pages A3 and 4. It asks for an order that they are liable to pay the costs and expenses incurred in respect to the preservation and enforcement of the claimant's rights, i.e. that in principle they are required to pay them, but as to the quantum, we ask that we seek either to agree them after the event or for directions to be
okay. All right.
Provided in due course.
Yes, I see. Okay. So I just make a note to see draft order about the fee.
The further tweak in respect to the draft order is paragraph 6, which refers to interest on the costs at 3% plus Euribor, but I don't think that's the appropriate rate because there is the specific rate of 9% in practice direction number 4 of 2017. It does give your honour liberty to apply some other rate, but we haven't actually put forward any evidence in support of Euribor plus 3%, so we would seek to revert to the 9% in the practice direction.
Tend to use IBOR anyway rather than Euribor, but that's another issue.
Yes, well, I think if the practice direction refers to IBOR for historic debts, but then it says going forward we should use 9%.
Okay. All right, well, I'll look at that if it arises. I hasten to add, this is all contingent upon clearly my ultimate decision on immediate judgment. The other contingent matter that I'd like you just to ventilate before Mr. Kamath responds, so he has an opportunity to look at it, is your claim for costs today. So your cost.
Yes, I don't think that's in the case line bundles, but was provided, and I hope you've got a copy of that.
I have a copy. I don't know whether Mr. Kamath has a copy.
I think it was emailed to him yesterday.
I'm sure the court will have sent it to him, but Mr. Kamath, have you seen their costs claim? What's called their cost schedule?
Yes, sir. By email, I have.
Oh, good. Okay. Well, that's excellent. So I just want Mr. Temple to explain to us what that is, so that you have an opportunity to address me upon it if you want to.
Yes, Your Honour, there is a question of the basis upon we would apply for our costs if we're successful. Is the starting point?
Yes, of course.
Of all the proceedings up to date, although there is still the cost claim outstanding, there would obviously have to be dealt with separately. The rules provide
that's what I wanted to clarify first of all.
Yes.
These are just the costs of this application, is that correct?
I will
They're not
double
the cost
check.
of the entire.
I think they are the costs of the entire thing to date, because the particulars of claim, etc., are really almost entirely for the things that we seek immediate judgment of today. If Your Honour is so minded to leave out some aspect, then there would have to be a rejigging.
The problem is that I have the statement of costs is not as detailed as it might be. So I don't know. I don't know to what the hours refer.
Well, you've got costs. Obviously, there's the fee earners setting out their hourly rates. The attendances on, I can see, is blank, and I understand that to be attendances on the claimants.
Yes.
So that's liaising.
So I don't know. I don't know what is. I don't know what is the cost. What are the costs of today, and what are the costs of the whole proceedings? And equally, I don't know what the disbursements and expenses are. It does explain what the others, but.
Well, I think the expenses and disbursements are largely council's fee. I'll be corrected if that's wrong. I think my fee. Yes, my fee for today, I think, is agreed at £10,000.
Yeah.
Translated to whatever that equals to in dollars. And then there's been one of my colleagues involved in other elements of this. So if you are minded to order them just for today, rather than for the proceedings to date, or some variation thereof, because of course there's been various witness statements which are for today, then I'm afraid it would be necessary for us to split them out and provide a new schedule.
Yes. Okay.
There's also the question of the basis, which it might be thought premature for me to comment upon at this stage, but we would seek at the very least that it's cost payable pursuant to a contract, which is under RDC 38.69, which is, I think, slightly more generous than standard basis costs, but not quite as generous as indemnity costs. And I think it's to do with the way in which the benefit of the doubt is resolved. Indemnity costs requires, I think, you to consider what has been unreasonably incurred, whereas contractual costs require you to consider what has been reasonably incurred.
Okay.
Now, if there's a difference there, I think it must be in terms of burdens of proof or the like. Yes. But I think it's premature, frankly, for me to comment on
premature. Okay, look, I think as far as I'm concerned, we've gone as far with this as we can at the moment. And in fact, we've still been quite economical about time. We've come up to the end of the hour and a quarter, and I think we've covered everything that needs to be covered, and have a bit of time in hand, given that we've dealt with both interests and costs as well on a contingent basis, I hasten to emphasize. So look, Mr. Kamath, lawyers sometimes need a bit of time to think about something. I'm sure that a layperson does too. You've heard a lot from Mr. Temple. I'd like to give you a little time just to prepare what you want to say to me. Shall we say 15 minutes? So I make it 2:30 Dubai time, 10:30 London time. Shall we then resume at 2:45 Dubai time, 11:15 London time? Okay. Okay, Mr. Kamath.
Or you're letting me know? I didn't get you, sir. You broke up.
I'm sorry, I can't hear what you're saying.
I said I couldn't hear you. So was that a question, or you asked me 15 minutes is okay?
I'm saying is 15 minutes okay? Well,
if you can give me 20, that will be good, sir.
Okay, I'm very happy to give you 20. We'll resume at 10 to 3
One
Dubai
question I
time.
do have, sir, because 229, is it normal practice to ask costs of the claimant's lawyers, or is it?
I'm sorry, what do you mean ask cost of the claimant's lawyers?
As in right now, the past 5-8 minutes we went on about.
Yes, there's a procedure which is called summary assessment of costs. So if I found today that they were entitled to have immediate judgment, I could assess the costs immediately if I felt I had enough material. And order them immediately. On the other hand, if you win and you tell me that you have certain costs, I could award you your costs today as well, subject to me thinking that I have enough material to assess them. Alternatively, either way, depending which way it goes, I may think I don't have enough material, and in which case I can order, for example, a payment on account of costs, but then say that another official of the court, usually the registrar, will assess the costs at another hearing. So, but all of that's up for grabs at the moment because we haven't come to any final decisions, but I'm just letting you know what the procedure is. So look, you take your 20 minutes now, and then you come back and you tell me what you want to say in response to what Mr. Temple has been telling me for the last hour and a quarter or so. All right, so we'll rise now for 20 minutes. What I suggest is you just turn your microphones and your cameras off, but don't actually exit the Teams. Otherwise, it might create technical problems. Okay.
Not a problem.
All right. See you in 20 minutes. Is everybody available to restart?
Yes, Your Honor.
Yes, Your Honor.
Thank you very much. So, Mr. Kameth, you have an hour and a half to tell me whatever you wish to tell me. So that it's now 20 to 3, 10 to 3 in Dubai time. So you have until 10 past 4 Dubai time.
Sure, sir. To start with, I'd like to apologize for getting off the tie, and we're not used to it. So I do apologize for the appearance, but it just restricts me about what I'm doing.
That's okay. I just want you to be able to present your case in the best possible way you can.
Yes. Yes. I would like to take you, like you've rightfully done, with the framing of the issues, if I might say so. When I'm addressing it, I might jump a bit from one issue to the other, not in the same sequence, but I'll try to focus on the way it has gone till date. I wish to start with the framework agreement, sorry, the facilities agreement, which is the agreement that we've started off with.
Yes.
And the first point of focus I'd like to be on is the framework agreement, which was one of the points that I had raised.
Yes.
Now, framework agreement appears 8 times in the facilities agreement. Now, one of the main reasons I wanted a proper defense filing by a trained professional, if you want to call it that, was for a point that Mr. Sharrett had drawn our attention to in the immediate judgment application, saying that the defendant, that is, defense filing, talks about framework agreement, but does not talk about what exactly it was meant to be. Now, if there was a trained professional who would be telling me that you got to back it up with documentation, which I have right now, evidence-wise, which was not submitted then, is it a possibility for me to present it now, sir?
What do you want to present? Sorry.
Well, so there's in all these discussions, you've been quite vocal about the way this whole agreement has been written is quite poor, in my opinion as well. It is not written well because it was subcontracted to a company called Emirates Legal, who wrote this agreement up, who were directed by the claimant, even though their payments were directed from our disbursements. So this company called Emirates Legal was handling the draft of this agreement. Now, facilities, while going towards the facilities agreement, am I allowed to present evidence that has not been presented yet, sir?
What is it?
Well, sir, it talks about what exactly is the framework agreement. Mr. Sharrett opened the door on it, saying that you've said that the framework agreement is critical. Nobody's seen it. We haven't signed it. We haven't seen it. But what was it about? Framework agreement was supposed to be the principal agreement, which talks about the rights, obligations, and the entire transaction, including the ECL's terms and conditions, were supposed to be incorporated into the framework agreement. It is a proposal or a letter of engagement, if you want to call it that, that was addressed to TAC, Ransasia, the claimant, which was also sent to us because we had engaged them on their behalf. It's a bit of a complicated mess, if you want to call it that. But that evidence we could not submit last year because I'm not trained in what we're doing. A trained professional would have told me that that evidence has to be included. Which was
okay, look, I think if you could, I'm going to let you produce this document now. Yes, we'll see what it is, and we'll see how we get on with it. Sure. And if Mr. Temple has a problem with it, then we'll try and deal with it if it's relevant. So I don't even know whether it's relevant or not yet. So let's just have a look at it and sure. See it. So what are you going to do? Are you going to?
Are you going to? It now, sir.
You have everybody's email addresses, do you?
I've got yours and Mr. Temple's.
Okay, well let's do that. Mr. Temple can always pass it on to his instructing
solicitors. If you can give me half a second, it'll be with you.
Yes, of course.
I have just set it, so it's a 4 MB file. It should come up now.
Okay, thank you. Let's see. I have it, thank you.
You have it, sir?
I do, yes. Just opening it. Okay, so this is a... sorry, Mr. Temple, has it arrived with you yet?
Not yet, Your Honour.
Well, let me just tell you what it is. It'll arrive, I suspect, on your desktop in a moment. It's a letter dated the 26th of January 2019 from Emirates Legal Consultants addressed to Mr. Sullivan at Ransasia Private Capital Limited in Hong Kong. and it is a letter concerning professional services agreement signed on 25th January. Proposal. Please note the proposal requires amendment, inadvertently left out. The amendment required to add is an additional scope of work, drafting the loan agreement / facility agreement. We understand this is the most important document in the entire transaction and should form the basis of the rest of the loan documents. Sending you this amended professional services agreement, blah de blah. Pursuant to your advice and instructions, prepared a legal opinion for securing 18-month revolving credit.
Page number 4, sir.
Yes, I'm just running through. Have you got it yet, Mr. Temple?
No, I'm afraid not. We may have some fairly stringent filters in place, so I'm not sure if it's been caught by one of those.
I mean, I can forward it to you if it's helpful. But,
no, it's just arrived.
Okay. And then they go on our understanding. Blah, blah, blah. Facility agreement, facility agreement. Okay. Okay, I see, Mr. Kamath, where you want to go to, which is the definition of the framework agreement as step 2. Is that right?
That's correct, sir.
Yes. Well, we'll wait for Mr. Temple to catch up.
Your Honour, I've now got at least step 2 part of it.
Okay, well, so you're up to page 4 there. So, Mr. Kamath, tell us what you want to say then, based on this document.
Right. Now, framework agreement was supposed to be a principal agreement, as it says. It sets out, it was supposed to, we had discussions in our office with the said gentleman called Mr. Mujataba, who was hired to draft these agreements on behalf of the lender. We had discussions with him, and this was supposed to have all those details in it as to what the rights and obligations of all the parties were. Now, if you look at, I mean, what Mr. Temple said was, it is just a simple contract now in the absence of this framework agreement, which nobody has seen, nobody knows about it. We did know about it, sir. It was supposed to have all this, including the transaction. The money that was lent to us was not for anything that Mados Trading could do. It was for a specific ECL project. The ECL project's terms and conditions, okay, are specific. They were supposed to be part of this framework agreement as we moved forward to the facilities agreement. Now, if you look at the facilities agreement, there's pretty much no rights that the borrower has other than the fact that there is interest to be paid and that we've been lent money to the ECL project, number 1. So it comes down to a level of mutual mistake here, wherein the framework agreement never got signed, even though I myself got into an absolute fracas with the same gentleman saying that we have not been given these agreements despite asking for use several times. That's also part of the defense that I have filed. I think you will find that under Exhibit 10 EL email trail 1.
sorry, let me, your defense, let me go to your defense and you can take me to the specific paragraph. Where is it? Where's defense? So which paragraph would you like me to look at?
So the exhibit 10.
Defense exhibit 10. Okay, let's have a look. Let's have a look at that then. Exhibit.
It's a whole trail of email. You'll see what I mean there.
Yes, I have that now. I have that February 2019. Yes, I'm just looking through exhibit 10. And there we see reference to the framework agreement on the 25th of February 2019 email, which is page E185 of the bundle. Okay. All right. So what do you want me to take from this email exchange?
Well, sir, I'll paint you a picture about what was happening in the background, which is partly captured in here. We have been chasing this company, which was hired by the claimant, to give us all the agreements so that we can vet it as a borrower.
Mm-hmm.
Okay, I'm pounding him for those documents which are being controlled, and he says that he has been hired by Ransasia Capital to create these agreements, and he has already passed it on to the lender. All those emails, if you read it, you'll find it there. If I miss some, there are probably other emails that I can supply to the court, which will say to that effect. Now, I've been quite vocal trying to get these documents through to me so that I can vet it in time, because the project is already running late, sir, because of the late disbursement, even though the court says that, you know, all the facilities agreement supersedes whatever has happened before pre-contract, as you mentioned. Right? So now I'm chasing these gentlemen for the framework agreement and every other agreement so that I can vet it properly, so that the contract terms can be settled properly. Now, there is also an email trail, which I think I might have added there or you might have missed, wherein the managing partner of Ransasia Capital, Mr. David Sullivan, came back with an email saying that if you don't stop hounding Emirates Legal for these documents, there will be no more disbursements. Right? Now, that is the scenario that is painted at the background here, wherein I have asked for these documents. The documents aren't sent to me. The project is running late, right? And we are all in a mad rush, as Mr. Temple rightly pointed out, that it's a expedited thing wherein we are running late and we don't have time to even vet the documents, despite me repeatedly asking for it. Now, coming back to the fact that the reason I'm tying this back is because there is mention in the filing. Mentioned in the filing of Mr. Sharad that I'm not telling him what the framework agreement is supposed to be. This is what it was supposed to be. It was supposed to have all the rights and obligations, as we had discussed with Mr. Mujtaba in person in our offices, including the ECL's terms and conditions, which has the force majeure condition. The point that if we don't produce enough, we are going to get stuck with no monies, no free cash flows, because they will grab that production and not pay a substantial amount of our bills. So the framework agreement, even if wasn't signed or cited in the first, second, or third draft, is supposed to cover this. We both missed it. We both missed it.
Okay, well, I'm perfectly willing to accept that. What I really need to know is the respect in which the absence of that agreement renders the facility agreement unworkable. That's what I need to know from you.
Yes, sir. That's where I'm getting to now. Now, if you look at the now think about it this way, sir. I have signed a contract with Eastern Coalfields Limited, whose draft, everything was supplied beforehand to the lender to include those terms into the facilities of the framework agreement. Why? Because the money has been lent not for us to trade in pipe, which is our main business, but for the Eastern Coalfields Limited project. So the terms and conditions of the Eastern Coalfields Limited has a bearing on the facilities agreement, or the way we are repaying this loan is also dependent upon what Eastern Coalfields Limited does to us and their contract terms. This is where the framework agreement comes in, Your Honor. This is why we can't be discounting the framework agreement as nothing but, well, we didn't see it, they didn't see it, so it's a facilities agreement, which is just the contract document. Let's get on with it. So it is not, sir. It was never meant to be. It was meant to cover everything, including the force majeure events that Eastern Coalfields Limited has agreed with COVID-19 1, 2, and 3 waves in India. This is where it renders the facilities agreement a bit bare, not a bit, quite a bit bare, as we move forward. On top of that, I'm being threatened not to bother the drafters of the agreement for drafts goes to unfair contracts terms, sir. Boilerplate agreements are made which are not provided to us in due time. We are under extreme stress here to get it done. Now you might say, Your Honor, that why the hell did you take the last 4.6 million disbursement? You could have just said no to the money. Now, you are in a project right now, your joint venture partners have put in money, you've put in money, and we're in the middle of it. Now, if Ransasia Capital, we said no to the money, then the transaction finance agreements which were signed between the term sheet and the facilities agreement, this is a timeline of around 3 to 4 months where around $6.4 million was lent to us. Those agreements are short-term agreements, they would have been called right there and then. I would have had no recourse to go back on anything. If you look at the facilities agreement, it talks about those short-term transaction finance agreements, which every time we signed with each of those disbursements, which are already delayed. So just discounting the framework agreement will not suffice, but it will be a travesty. If you just said framework agreement doesn't exist, let's get on with it, because that's what was supposed to do. All of us missed it. Each and every one of us, everyone at Ransasia, everyone at our side.
Well, it might be said that the reason that everybody missed it because it wasn't that important.
Well, sir, if you look at this EL engagement letter, right, this was signed by Ransasia Capital accepting this. It was supposed to be a principal agreement.
Yes.
To be signed simultaneously, sir, as per the facilities agreement. Didn't happen. It's a common mutual mistake, if you want to call it that, sir. But I'm just a layman putting it out.
No, I understand. I know that you're using certain words as a layman, but I understand what you're saying.
Yes, sir. So that's the framework agreement for you, sir. And I will also send you, once I pull out the emails, about a strict email from David Sullivan telling me to back off. Otherwise, there'll be no more monies. I can send that to you, sir, once this session is over. I don't want to waste more time pulling that out.
Yeah, I'm not sure that that's extreme. That's particularly helpful to me at the moment.
Yes, sir. Yes, sir. All right.
Okay. Yes, thank you. I have that point.
Thank you, sir. Now I'm going back to the facilities agreement, which sorry. Right now once the construction of the agreement is all done with and we've dealt with the framework agreement, I would like to go to the disruption event, sir.
Yes, of course.
Now, if we go to the definition of the disruption event, again, sir, I would like to remind the Honorable Court that the disruption event was not supposed to be just a simple thing sitting there. It was supposed to include ECL's terms of a disruption event, which they call a force majeure event. Now, even in my limited understanding here, sir, this is not a very well written disruption event clause. It talks about if
sorry, Mr. Kant, would you just forgive me while I actually get it up on screen in front of me?
Sure, sir. Sure, sir. It's page number 6, sir, of the facilities agreement.
Yeah, just give me 2 seconds. I'll tell you when I'm there, and then you can carry on.
Sorry, sir, I have a drink of water.
No, that's okay. Everything takes a bit of time on the internet. Okay, I have the definition here in front of me. Thank you.
Again, it was supposed to be read with the framework agreement force majeure clauses of ECL. Now, a material disruption to those payments or communication systems or to those financial markets which are in case required to operate in order for payments to be made in connection with the facility or otherwise transaction contemplated, but the transaction documents to be carried out. One of the transaction documents, Your Honor, is the framework agreement. There is no ambiguity here, sir.
Yes.
Now, imagine this, sir. Why would I agree to a contract which just talks about the failure of a treasury system? Now, even in this, that the last paragraph of B is not caused by and is beyond the control of the party whose operations are disrupted. Our operations were disrupted, sir. What do you mean by operations? Operations is the mining operations that were being carried out at Eastern Coalfields Limited. Those operations were disrupted. It is just not about the treasury payment systems that were disrupted, that it is called a disruption event. It's a very myopic view of looking at it, sir. Again, should be read with the framework agreement. It's not there. Even this, the last line says the party whose operations are disrupted. We were disrupted because Eastern Coalfields Limited agreed. So did Coal India. So did the government of India, saying that COVID 1, 2, and 3 are force majeure conditions which disrupted everybody's operations. And the second wave, sir, which was we were in the middle of when this claim was lodged, was horrific. We lost workers at site who died coming to work, sir. That is the level at which we were in India. Now, coming back to that's the disruption event, so that I've covered. Now we have the jurisdictional clause, sir, clause 31.5. I'd like to address that.
Yes.
Now, I'd like to also request you to bring up the exhibit that was sent yesterday, I believe, by which Mr. Temple also referred to, which is the sorry, sir, I'm just bringing it up. Give me a minute.
You're talking about Mr. Sharratt's, the exhibit to Mr. Sharratt's fourth witness statement. Is that right?
That's correct. Which Mr. Temple also referred to.
Yes.
Which was, I believe, this thing about scope and reach of jurisdictional clauses. It's in principle, it comes down to the Hague Convention, which is not really applicable to us, I believe, it is for the Europeans. So we've got to set that aside. Or that Brussels retraction thing, that is also for Europeans. Now, what it says that the question is one of construction and interpretation.
Yes.
Now, construction of this framework, facilities agreement, as we all agree, is not very good. Now, coming back to the linguistics of this, it comes down to the language. Mr. Temple said that they may be 31.6 allowed different jurisdiction. I beg to differ, sir. The word that would have set this apart is notwithstanding. The word notwithstanding, that word is missing, sir. The framers of this agreement, which was a boilerplate agreement, which somebody with lesser skills than most of the people present on this hearing has drafted, has literally screwed this up for everyone. 31.5, sir, in my opinion, is final. DIFC courts, in an asymmetric clause, as I've read it, sir, it says it binds one party to it, not both. Here it binds both parties and it is final and binding. That is the finality. It's like death. You die by this or you live by this. Unless that a word was introduced that's saying it's notwithstanding 31.5, it could have been an asymmetric clause. This, sir, is an exclusive jurisdiction clause which falls under DIFC.
What about the word however in 31.6?
Where is it, sir?
So if you go back to the facility agreement.
Yes, sir, may however bring proceedings, notwithstanding, yes. Sir.
Well, doesn't notwithstanding, however, mean the same?
Well, so the one has to override the other clause, right? So if it is 31.6 needs to override 31.5, again comes back to the fact that only one party should have been bound by the exclusivity clause. the words final and binding kills the clause 31.6 ab initio.
So your argument is that clause 31.6 is meaningless, is that right?
That's correct, sir. And now I'll take you to the part where it says parties. If you go back to the second page of the facilities agreement, it clearly says who the parties are. It's all of us, other than the personal guarantee signatories. The personal signatories are not bound by this. Just myself, Mr. Sridhar, and Mrs. Meenu. They're not bound by this clause. The lender is free, as they have in Australia and in India and other places, to go after the guarantors. Prima facie, 31.6 will not apply to the main borrowers, because the parties, as explained in the page number 2, is very categorical. It's all of us.
So you say that 31.5 31.5 only applies to the bank's claims against the corporate.
That's correct, sir.
Okay, the corporate defendants.
That's it, sir. For corporate defendants, 31.6 is irrelevant.
Okay.
So now we come, I'm going to dovetail this with with what I've said, which might have sound harsh when I submitted what I did submit in the past couple of days, about the freezing order or the provisional attachment order.
Okay.
Okay. Now I would like to bring to the attention of the court that let us, for arguments, assume that the competent court is the DIFC court. Okay.
Yep.
Now, I'd like to bring the way the jurisdictional clauses are applied right across UAE. The jurisdictional system, you've got the UAE federal system, which is only followed by Al Quwain, Sharjah, and a couple other emirates. But the federal judicial system is not followed by Abu Dhabi, Dubai, and Ras Al Khaimah. These three have their own judicial system. I'm not talking about the law, sir. Judicial system. Correct? Competent court is not DIFC because they've gone to Abu Dhabi. Now, I would like to bring you, sir, to the fourth witness statements exhibit. Not exhibit, it's a fourth witness statement itself of Mr. Sharad.
Yes, just again, allow me to bring it up on the screen.
By all means, sir.
Yes, I have it. Thank you.
All right. Just.
You take your time.
Sorry, sir.
No, it's okay.
Right. Now, I would like to bring you to point number 9 and 10, sir.
Yes, I have them.
Right. 9 is a no-brainer, sir. 10. Sorry, not 9. Sorry. 10. Point number 10, which talks about the cabinet decision. I'd like you to look at 10 subclause 3.
Yes, I have that.
If the lawsuit was previously filed, the competent court, the seizure order referred to in clause 1 of this article may be requested by the court hearing the case. Correct? Yes. Let us assume that the competent court is DIFC, sir, for argument's sake. I now bring you up to the same exhibit, page number 7 of the exhibit, which is signed by Ms. Maitha, one of the registrars.
So the exhibit, page 7 of the exhibit. Okay, that's
LS4. Yes, sir.
Bear with me 1 second. It's not. So page 7. So it begins at 2008. So that will be 2015. Page 7. Is that the document
that starts with English translation at the top, sir.
Yes, then I have that. Thank you very
Right.
much.
Now, here's the argument, sir. As per what Mr. Sharad has submitted in his witness statement, the competent court has to request for the attachment order. Correct? Where do you see a request here, sir? It is not even addressed to the Abu Dhabi Judicial Department. It says to whom it may concern that there is a case here at DIFC for these defendants. That's it. Where is the request, sir, that is required by 10.3 of their submission, which says if the lawsuit is already been in process in a competent court, which again I dispute, sir.
But
the seizure order,
I don't mean to interrupt your submission, which is very interesting. But if the Abu Dhabi court received this, and this was a defective note from this court, the DIFC court, and if the DIFC court did not have the power to request the Abu Dhabi court to grant the preliminary attachment, because that would only be granted, as I understand your submission, by the court before which the substantive hearing is proceeding. Wouldn't the Abu Dhabi court have simply refused then to have granted the order?
well, sir, I can't say what the Abu Dhabi court was thinking at that moment in time, because we have never been served those documents, sir. We asked for it on the 16th of November 2021 in a proper Part 19 submission, asking for those documents. But we were denied using 19.6, which now appears to be a fraudulent misrepresentation, sir. We were misled.
Well, we'll come to the fraudulent misrepresentation in a moment.
It dovetails, sir. So you let me with this. So yeah. Sorry, sir.
Let me just pursue the issue here. So let us assume that this request is made to the Abu Dhabi court, and if you're right, it's a defective request. So then wouldn't it have been an error on the part of the Abu Dhabi court to have granted the order?
Well, to respond to that, sir, we would have known if it was an error if this order was serviced to us, sir. We asked for it. Okay. Had they serviced it to us on the 16th of November, instead of concealing it in the guise of Part 19.6, we could have pursued it, sir. Even till date, I don't know where they've gotten this, how they've gotten this. And what they have told the bank to make it such that for 6 months, I had to use my credit card to pay the bills for the company.
So what did you go to the Abu Dhabi court and say, why have you made this order?
We didn't even know that, sir. We were not given this information even by our bank. They said that it was provided, there is a lien on it, and it is a permanent lien. You have to go back to the people who have put the lien on it.
Yeah, but did your bank inform you that they've been granted by the Abu Dhabi court?
They said there's an order.
From the Abu Dhabi court?
A court order, that's it. Hence, on the 16th of November, out of desperation, because more than doing our submissions to the Honorable Court, sir, my business was suffering. I could not quote anybody. I couldn't do anything.
No, let me just have a look. Let me just have a look at your defense. So 25th November 2021, your defense. Then let me have a look.
The last 2 pages says so, sir.
Yes, I'm just bear with me a second.
Sir, can I take your leave to get a glass of water, sir?
Yes, of course you can.
Thank you, sir. I'm back.
That's okay. I'm just trying to find out the date when you first knew that there was an order by the Abu Dhabi court.
Well, sir, it will be the 16th of November, sir.
16th of November, what year?
2021, sir. These are all 2021.
So you knew there was an order of the Abu Dhabi court in 16th November 2021.
We knew about it. I mean, it's not documented, but we knew something was happening around in middle of October.
No, well, I just want to make sure, I just want to know, and I want to be precise, that you knew it was the Abu Dhabi court that had made that order.
Yes, sir. We spoke to the. Let me get back to what I said in the defense. Yes, sir. We knew around that time that there was first we were told that there's a court order, a lien marked of $40 million.
Yes.
Dirhams. The bank would not tell us who it was from which court it was, but we subsequently found out it was the Abu Dhabi courts.
Okay.
But there was no copies given to us by the bank or the plaintiff.
Okay. And did you approach the Abu Dhabi court?
We did, sir. From the we approached the ADJD, which is the Abu Dhabi Judicial Department.
Okay, you approached the Abu Dhabi Judicial Department.
That's correct, sir. And somewhere around that time, when we asked the claimant for copies of what they'd submitted.
Okay, and what happened when you went to the Abu Dhabi Judicial Department?
We went through the process wherein the Abu Dhabi is slightly different from Dubai, sir. I mean, don't get me wrong, it's much more easier in Dubai. We had to go through what is called as a PRO with the public relations officer. He actually went to the courts. They said, we don't have anything for you here. He was sent back. And then we approached the ADJD with the name of the company, which was also changed because Mados Trading Establishment was changed to Mados Trading Company before this transaction happened.
Okay.
And after going through the process, we knew that there was a lien marked. Is when I asked on the 16th of November to the claimant's lawyers, asking for all the details on it.
Yes, but I mean, did you make any application to the court to discharge that?
No, sir, we did not do it. We did not know it about it. Half the time, a majority of the time was spent trying to find out what was happening.
Yes, I mean, did you go to lawyers in Abu Dhabi?
No, sir, we could not afford at that moment in time. Because everything costs money, Your Honor, and our accounts were frozen. Upfront payments, how do we do it?
Okay, sorry, do carry on. That's fine, thank you.
Okay, so I won't deny this, sir, that we were in a cash flow crunch. Money, everything was stuck in India. Monies weren't coming through, bills weren't being passed because we were just stuck because of the COVID. Our checks here were getting bounced, which we had to make good. Otherwise, it would have been a criminal offense to the signatories of the check, which was a lady, Miss Meenu Sridhar, who's married to my business partner here. So that is the level of which at it went to. Nobody informed. Had somebody informed us that there's a lien marked and the checks are going to bounce and it's a criminal offense at that moment in time, we would have taken some action. Right? So despite that, in my submissions, I've written here that we did not know what was happening. Even here, it talks about that in my defense filing in an order wherein I've requested you as in the court or the justices to give me pro bono lawyers to defend this. Right. So that goes to your jurisdiction, that goes to your attachment order, sir, and the effect it had, and why I've written what I've written so strongly about it being fraudulent misrepresentation. Now, here I'd also like to bring something that I disagree with your lordship. That, sir, you saying that the defendants can put a separate claim for the losses they have incurred is patently one-sided, sir. The reason for this, sir, we were in the middle of the whole lawsuit here is about money, returning repayment of the principal and the interest, correct? There's no other, as far as I'm concerned. What motives the claimants have is different. I have always been wanting to repay this even before the maturity of the loan, because I knew this was coming. The late disbursement was going to affect our ability to repay. And I've got emails to that effect. I'll come to that in a minute. Now, Your Honor, you said that they can file a separate claim. It goes far beyond that, sir. In February 2022, sir, we're in the middle, actually we're in the middle from December itself, of a investment with a family office, which I've also documented at the time. This is not an afterthought that I'm having now. I have continuously been telling them that we have an investor who is interested in settling this, taking over the project and settling your debt. I need a letter from you. And we went into the details of the letter. The letter came in a very legal format. And then they found out about the freezing order when they did a legal due diligence. Even that I have mentioned. Would you like me to take you to the part, sir?
You must follow your own course. Whatever you think is important for me to see, show it to me.
Right, sir. Now, if you can allow me the liberty for a minute, sir, let me just.
Of course, take your time.
Now, first thing I'd like to take you to is SHF2, sir. This is my evidentiary documents in support of my second witness statement, I believe.
Your second witness statement, right? Just bear with me and I'll go to that. Yes, I have the exhibit there. Where would you like to go?
I just want you to look at, first, I'd like you to re-emphasize my application to them, page number 57, sorry, sir, page number 56 and 57.
Okay, I have them in front of me.
This is what I've just said. I'd applied for page part 19 and declined the very next day, citing 19.6, saying just go and submit your defense. It doesn't matter what we have submitted as a freezing order, which is wrong.
So can I just read the 16th of November letter then, sure, please?
16th and 17th, please, sir.
Yes, just give me 5 minutes. Well, less than 5 minutes to read then. So that's letter to translation. And then the next day from Stevenson Harwood. Okay, thank you. Yes, I've looked at those.
As a layman, sir, this is nothing, in my opinion, other than concealment with ulterior motive. That's just me.
So, yeah, so let me just make a note of that. H.
Hence the harsh word of fraud, sir.
Yes, I understand your argument. Okay.
Right, sir. Carrying on from the after effects, wherein I disagree with your lordship about the fact that I can just go and put another claim and recover what has happened because of this illegal provisional attachment order, is how I would phrase it. Maybe harsh as far as wording is concerned, but that's how I see it. Now, same document, sir, I'd like to take you through to page number 60, sir.
Yes, okay. Give me a second. Yes, I have that.
Page number 60 and 61, sir, if you can have a read of it from bottom up.
I will do. From the bottom up.
So 63 to 60, sir.
Okay, well then let me go to 63. Right, okay, that's the beginning of the email trail. Right, 25th May. Okay.
All right, sir. So here we are, sir. We have a captive. Now coming back to page number 60, sir.
Yes.
We have a legal due diligence failing at the debt knell. We're expecting a term sheet with, I mean, it's a family office which is got, it's old money, sir. That's whom we were courting for a very long time. So we entered into due diligence somewhere in December 2021 with the sole objective, sir, to bring them over as for working capital as well as to take over the loans of Ransasia Capital and pay TAC off and finish this. Now, they find out because they are well entrenched here in Abu Dhabi and everywhere else, and they go through the Bank of Baroda, whom our bankers are, they get in touch with them. They are telling them that there is a freezing order. We get asked about it, saying that, why didn't you contest this freezing order? Did you know about this freezing order? Tomorrow, if we lent you money for working capital, because at this moment in time, sir, my project is stalling. I need working capital. Right, so I'm quoting these people for both of those things. They simply said and walked away saying that, what if tomorrow there is another ex parte freezing order? My money is stuck, you can't use it, then what? So by your own admission, sir, a simple claim won't do, sir, here. The whole claim right
Sorry,
now.
what do you mean by your own admission?
Sir, when you said, sir, that I am obligated to pay, the defendants are obligated to pay the loan. And if there is a dispute owing to this freezing order, we should go claim damages from the claimant. That's what you had summarized, right? Not summarized, but that's what you had commented last time, sir. When Mr.
No, please don't put words in my mouth.
Sorry, sir, I didn't get it.
Yeah,
I mean, my interpretation, sir. Is that right?
It's interpretation, but it's very disrespectful to put words in the mouth of the court. What I was doing was repeating back to Mr. Temple what he was saying, and his submission is that even if you have a claim in relation to this freezing order, you are bound by the terms of the facilities agreement that you have signed to make payment. And if you have a claim, you make a separate claim, but don't put words in my mouth.
My apologies, sir. My personal apologies. It wasn't meant to be that.
Okay.
Can I continue, sir?
Yes, do.
So applying a separate claim there, sir, is not enough remedy here. We lost the opportunity, sir, of clearing this loan using this investor. Again, sir, my apologies. It wasn't meant to come across like that. Right? So this is part one of that, sir, of the effects of the freezing order. The bona fides of the defendant, sir, can be seen right from, I take you to page number, sorry, sir, page number, right, page number 65, sir. 68, my mistake, sir.
I haven't.
Now, the page number 68, sir, is July 8th, 2019. Can I please request you to read from the bottom up, sir, again?
Yes, of course.
73 and above, sir.
Okay, go back to 73. Go to 70. To 73. Okay. Okay, so I've had a scan through. It's about the Bank of Baroda refinancing your indebtedness to the claimant.
That's correct, sir. Now, what I'm trying to prove here are the bona fides of the defendant, sir. To start with, it is 3rd of July 2019. The facilities agreement, Your Honor, has been signed on the 12th or the 13th of March 2019. We are not due, we as in the defendants are not even due to make the first repayments in the first 9 months. It is not supposed to be 6, sir. It's supposed to be 9 as per the term sheet. It was supposed to be amended. But anyways, we are within even the 6 months of making the first payment. And I have offered a repayment of the loans or refinance and repayment of the loans. The reason for that is, sir, about what I've mentioned in the email as well, saying that we are delayed and there is going to be repercussions with free cash flows available to repay these loans to meet the debt obligations.
But Mr. Kathy, there is a distinction between being liable to pay the loan and being able to repay the loan. Everything you're telling me is that you have problems being able to repay because of the impact of these events on your business and your inability to refinance the loan. What you haven't yet told me is why the loan is ineffective.
You mean the facilities agreement is ineffective, sir?
Well, whether the facilities agreement is ineffective is a piece of paper. You admit that you've had the money. You admit that you're liable to pay interest on it.
Right, sir.
So why shouldn't you repay it?
So we are liable as per the facilities agreement and all the events that have occurred since then, which included COVID-19, a major part of it. What other thing I have mentioned there, which the framework agreement was supposed to capture, was the force majeure conditions, including the rains that have, there is dry months, Your Honor, and there are wet months in mining. The wet months in India are heavy, monsoon-wise. We're talking about July, August, September, which are washout. Most of June is also a washout. Timing is everything in mining, and I've time and again, even before the facilities agreement was signed, time and again, sir, I have made this aware to the lender, saying that your monies are going to be stuck. I have those emails as well, along with ECL's warning letters to this effect. So I have kept them up. I'm showing you the bona fides of the defendant, sir. Nothing else. So that is where the inability of paying interest comes in, sir, or repaying the loan. We have made the efforts to refinance it so that the money can be repaid back ahead of schedule before even the first repayment is due.
But inability to pay is not a defense to liability to pay.
No, sir, it is not a defense. I'm just trying to tell you.
So I need to see, so this is an application for in relation to liability to pay. And so I need from you to be persuaded that you have no liability. Because if you have a liability, then there will be judgment. And then the question is, how that judgment is enforced and how it's honored. But that's a different issue because that's about the ability to pay. But we're only today concerned with the liability to pay.
Well, so the liability to pay goes back to the fact that there should have been the framework agreement which would have covered our liability not to pay in the event of such measures.
So you say that the framework agreement
yes, sir.
would have provided that in the event of what?
COVID-19, monsoons, rights
So,
and obligations. Yes, sir.
so
The
in the
entire
event of
transaction,
COVID, monsoons, or anything else?
Any natural disasters, sir.
In the event of natural disasters, you would have been okay. Then in those events, then there would have been no liability to repay the loan or interest. Is that what you're saying?
What I would be saying is that that amount of time and the contract would have been the liability to pay would have to be renegotiated.
So the liability to pay would have to been renegotiated. That's what the framework agreement.
That's correct, sir. It's supposed to have all those things. Imagine this, sir. You have taken a loan for a car, and the running of the car is as per the warranties. That is your framework agreement. The money wasn't given to us just to buy anything and put it into trading of pipe. It was for the ECL project. So
that's in the that's in the facility agreement. The facility agreement says that you have to use it for the project. Absolutely.
That's correct, sir. And the back-to-back of those contracts was supposed to be in the framework agreement, which what I've sent to you from Emirates Legal says so. It's a principal agreement.
So the fact that we don't have a framework agreement, how does that help?
Well, the fact that it's a common mistake, sir. It's a mutual mistake that we both have entered into, which renders the contract to a large extent voidable.
So you say that the facility agreement is now voidable. Is that right?
That's correct, sir. Based on mutual mistake, as well as, I mean, I wasn't as good borrowers, if you want to call us that, before the facility agreement was signed. We have been hammering the people to give us those agreements to be able to be vetted. We have both erred in not pushing and getting that framework agreement done and signed up.
So if the facility agreement is voidable, what steps have you taken to void it?
We haven't taken any steps to void it, sir, because this is something that our intentions were always to renegotiate. If you look at all my emails about rollover and providing proposals, these are all aimed at that, to renegotiate the contract. Now that it has come for immediate judgment application, Your Honor, I have to mention this, that it is voidable. We have to go back to the drawing board and renegotiate this based on the fact that mutual mistakes were made, misrepresentations happened. Our ability to refinance them got hit. So that's carrying on to the SHF2, sir. Just touching upon it is the witness statement, the SHF2 evidentiary document, sir. Page number 74.
Yes.
Page number 74 onwards to page number 84, sir.
Okay, well, that's a lot for me to read. Let me just have a spin through that.
Please.
'85, right? Let's have a look. So these are the Texas people, yes.
Yes.
And you mentioned some other possible
Yes, sir.
people. Okay, I've looked at this before. So tell me what your point is here.
In total, so there were 4 bona fide takeover proposals that were put in.
This is
Now,
proposals for refinancing.
Refinancing, takeover, the whole lot. It all
Yes.
is aimed at finishing the loan after renegotiating it based upon what we were encountering with COVID-19, the framework agreement, the whole lot. Even now, sir, on the 22nd of November 2022, this proposal came in, which we've put to the borrower, sorry, so the lender, and we haven't received any conclusive confirmation if they wish for us to proceed with it.
Mm-hmm.
So it's just proving a bona fide, sir. We want to renegotiate this loan and conclude on it. Actually, I can even take you to the facilities agreement 31.4, which talks about negotiated/mediated settlement failing. Then it goes on to the jurisdiction clause of 31.5 when DIFC comes in.
So what's the point you want to make?
Well, the point I'm trying to make here, sir, is that we have not, to start with, sir, it is voidable. If you wanted to do it, we would have. We want to renegotiate this based on the fact that the impact is there and it was supposed to be covered with framework agreement. And we'd like a mediated settlement of this, sir.
Have you ever proposed that?
We have been negotiating in good faith, sir.
Because you entered into a settlement agreement, didn't you?
We did, sir. We were discussing multiple settlement agreements.
But you actually signed. Signed an agreement. You signed the payment deed. That was in March, wasn't it?
That's correct, sir.
And you didn't honor it.
The primary reason then we couldn't honor it because the due diligence failed, sir, which I mentioned to you in May. Our settlement deed was signed on 2 things to accomplish 2 things. One was to get his unfrozen the bank account. The second one was we were in the middle of due diligence for this party we mentioned to Nav Money Mines in emails dated the May.
Well, the claimants lifted the freezing order on the signature of this payment deed, didn't they? In March. They did,
sir. But that's
so it was no longer a problem after that, was it?
No, sir. The suspicion remained with the client when they did a due diligence that there was a freezing order which was ex parte, uncontested ex parte freezing order.
But it had gone by then.
No, sir. Their query, which I have mentioned that in my submission as well, and in the email as well, is that the suspicion was that tomorrow if we bring in working capital, can Ransasia Capital further go and put in an ex parte order freezing it?
But that's their commercial decision. I mean, the fact is there wasn't a freezing order after March, was there?
But there was a history of a freezing order, which was ex parte, sir.
Yes.
This goes a long way. Trust goes a long way in these matters, and they just lost it.
Yes.
Completely lost it.
But you signed a payment deed. The freezing order was lifted, but you didn't make any payment. You made $59,000 payment under it.
Yes, sir. The payment deed was signed. 2 things again. We wanted the unfreezing to be lifted. So that was a condition subsequent.
Yes.
Number 1. Second, we were quite, even in my emails I've sent, we are confident we can do this because we have this investor lined up to do a one-time settlement with you. Even that has been recorded during that time. those are the strengths on which we signed the payment deed. So those are the facts of the case that I was presented, sir, for the effects of the freezing order. We've covered framework agreement. We've covered, I believe, the jurisdiction clauses, sir, and we have covered the ECL contract disruption event. What else is remaining? Right now, I want to touch upon the on a couple of points of law, if that is what it's called, especially relating to the personal guarantees, sir.
Yes.
Now, my personal guarantees are in Australia, and there are certain codes like the National Credit Code that in Australia it's followed. A similar spin-off of that is I
But
believe
your personal guarantee is subject to DIFC law, isn't it?
And Australia, sir. There are two.
And Australia. Let's have a look at it, shall we?
Sure, sir.
So personal guarantee, yours, that's G5 from G121 onwards. Okay. So we'll have a look at the jurisdiction clause.
For the DIFC one, right, sir?
Well, you only the only guarantee I have before me, and the only guarantee that's produced to this court is subject to the jurisdiction of this court.
Right.
Governing law and jurisdiction. The guarantor, clause 11.1, the guarantor irrevocably agrees that this personal guarantee shall be governed and construed by, in accordance with the laws of the DIFC, irrevocably agree, 11.2, irrevocably agrees that the DIFC courts are the most appropriate and convenient courts to settle any matter. No, I can't see any. I can't see any reference to Australia here. I'm sorry.
Yes, so there are two of them, sir. Even for the other defendants, there is DIFC and India, and I have got DIFC and Australia.
So there are other guarantees in other jurisdictions, is what you're telling me.
That's correct, sir.
But I'm not concerned with those. I'm only concerned with this guarantee.
That's fine, sir. Coming back to this one, this also refers back to the framework agreement again. Now, the reason I brought this up is because there are laws. Sorry, sir.
That is true. There is reference to you're right. There's reference to the framework agreement in this.
That's it. Now, the reason I'm saying that, sir, I know you said that you're not concerned about Australian laws or Australian payment guarantees is because Australia is part of the Commonwealth, sir. We're all part of this.
Yes, but it has nothing to. It could be part of the moon, as far as I'm concerned. It has nothing to do with the jurisdiction of this court.
Let me take you to where I see this coming apart,
okay.
Sir. Do allow me a layman's couple of minutes.
Okay. No, I will allow you anything you want within reason.
All right. The framework agreement is supposed to be a principal agreement, as I've shown you through the email that I forwarded it to you. Now, as per Australian law, sir, which is part of the Commonwealth, there's something called as the Unfair Contract Terms Act, under which there is the National Credit Code Act, which deals in personal guarantees. This is very specific as far as I'm concerned in Australia, sir, which I'm hoping there's something similar here. I'm not a trained lawyer. I'm sure there must be something in the UK law as well, that if the underlying credit documents are not provided to the guarantor 15 days before the signing of the personal guarantees, the personal guarantees are voided ab initio. This is what the National Credit Code says, sir, in Australia.
Okay.
There's chapter and verse which I can send to you. I'm sure you're aware of it.
Well, Australian law doesn't apply in the DIFC.
I understand, sir. I'm trying to say that there must be something similar as far as the Unfair Contract Terms Act is concerned when it comes to disclosure of critical credit documents which are not passed on to the guarantors.
So are you said so? Well, let's assume for the moment, and I will, because you're a litigant in person, I will look at the law in the DIFC on that. But let's assume for the moment that there is something similar. So what credit documents were you not supplied with?
The framework agreement, sir.
The framework agreement doesn't exist, so you were not supplied with a non-existent agreement.
That is what I'm saying, sir. I signed a contract guarantee based upon the promise that a framework agreement, a credit essential principal agreement will be provided to me.
I understand. I get it. I get the point. Yeah. Okay. Now I understand the point.
Sorry, I'm not.
No. It's me. It's not you. It's fine.
So by definition, sir, if we go back to the Emirates Legal's email that I sent to you, the rights and obligations of each of the parties were supposed to be in it.
I understand. I've got the point now.
Yes, I'll move on, sir. Can you kindly tell me, sir, which other points are missing? Because I've in all this.
Okay, let me
Sorry,
just.
sir. I really apologize.
No, not at all. I will help you. You haven't. Do you feel that you've addressed me on the delays in dispersing the loan monies? Is that your force majeure point? Okay, framework agreement we've dealt with. You say in your defense there was no meeting of minds with regard to facility agreement.
Yes, sir.
I'll
give you a couple of examples which I can back up with
okay.
As well. Now, Mr. Temple has mentioned that the facilities agreement supersedes everything else.
Yeah.
Right? Now, the point of the matter remains at the meeting of the minds. If you look at our term sheet and the email that Mr. Temple was referring to, I keep going back to the points that, number one, it was supposed to be a 24-month non-revolving, non-recourse. That Mr. Temple appears a bit. Again, there is a document here which talks about it needing to be a 24-month revolving non-recourse facility. Yes. This was at the term sheet level. Now, from the term sheet level, when the actual agreement came about, during all these discussions, it was curtailed back to 18 months. The first payment was to happen at 9 months, whereas the facilities agreement was 6 months, subject to certain things in the framework agreement, which allowed us to stretch it.
Okay.
This is where the meeting of the minds did not occur.
But you signed the agreement. Yes,
sir. We did, sir, and I'd like to bring you back to that about how, in what circumstances it was signed. The entire project was, I have in the emails that Mr. Temple has said, I have gone back and forth on certain points. Then all of a sudden you'll see that I have agreed to it. This was based on a phone call that I received from Mados, which is Miss Mary Attap,
yes,
who said that if you drag this anymore, the disbursements won't happen.
Yeah.
This is the only piece that is not on email, so even there I can prove to you on email. If you give me some time, I'll fish it out, wherein we are told by even the managing partner that if we push it too hard, if you ask for more documents to be vetted, you will not get any money. I have those emails. Those are the conditions under which we both mistakenly did not push hard to get the framework agreement or hard at all. We signed it because without the money, we would have, all the loans would have been called in. Again, okay, sir, you would be right in saying that you shouldn't have taken the money, in which case the other transaction finance documents would have kicked in which case immediately all those loans, $6.4 million till then, would have been needing to be paid.
Mm-hmm.
And during this process, Your Honor, right from the term sheet to the delay of the payments, the disbursements, none of it was adhered to, owing to their own fund shortage, the borrower, the lender. Again, you could say the facilities agreement, supersedes that, But that is the background. And even going into the facilities agreement and the final disbursement, Your Honor, I, in good faith, with the right idea in mind, I had been warning them on email. It is all there in the defense pack, I think, warning them about the fate of the project if we did not disperse soon enough, with ECL's backup documentation warning us about it.
Okay. Okay, there was one other point too
Yes,
that Mr. Temple raised, I think, in addition to my summary of the defenses that you had, which was you had said that there was an agreed rollover.
Yes, sir. I don't know which email he's referring to, sir.
I can tell you, sorry, it's a point at his skeleton at paragraph 26.4, K9. Let me go to K9 and then I can tell you this was not a point that I had captured in advance. So at paragraph 10 of the first section, paragraph 8 of the second section of the defense, you suggest that a rollover of the facility agreement was agreed, and you
Yes,
refer to Exhibit 20. And
yes. A minute, sir.
So shall we have a look at Exhibit 20?
Yes, sir. I'm pulling it up.
Which is E231. E231. Yes, 8th of June.
2021.
Yes. So this is the rollover point.
Oh, yeah. Right.
So do you want to tell me about that?
Yes, sir. Just give me a minute, sir. Let me just. Yes, sir. We were the initiatives when the maturity date of the first repayment in December 2020 came and went. Discussions with the borrower, the lender and the borrower took up in February to arrive at some sort of a rollover of the loan because of whatever was happening with the world with COVID-19. This was even before the second wave had hit India. There was a recognition amongst the lenders that something needs to be done. So we started discussions in earnest. We even came to a term sheet for the lender to take up a pledge on the equity on the Indian entity, take over the ECB. We signed it all up, but the sticking point came to the pledge of the shares in India, which we could not do because in the Western world is a different kettle of fish when it comes to contracts. In India, it's very personal, especially for coal, which comes under the Essential Commodities Act. And there's a lot of pilferage. When I say pilferage, sir, it is daylight robbery of the nation's resources by unscrupulous partners or unscrupulous people. So the directors of India are personally criminally liable for any overages in what we have given them and what the in-situ or what coal is there. So the rollover discussions collapsed there because there was no, the liability remained with the Indian directors, whereas the shareholding was supposed to pass over to Ransasia Capital as part of that rollover deal. This was between February 2021 to around June 2021 when it collapsed. We had actually signed the term sheet in good faith to save the project and to save the monies.
Okay, anything else you want to say on that?
That's about it, sir. Thank you.
Okay. Is there anything that you would like to say about interest?
The interest payable, the 20.2%, sir?
Yes.
Well, sir, I believe it is patently high given the circumstances. It was supposed to be part of the framework agreement that if we get it, the framework agreement also was supposed to have the ability to adjust the payments in the event that the production overran or there was issues with production, because I'd been pinging them right from December that this is going to affect our abilities in production.
Okay. And anything else of interest at all?
That is about it, sir. I've
Okay.
also asked for the interest rate rebate in one of these emails saying that we needed to rework the deal.
Yes, I see. Good. Right. And is there anything you'd like to say about costs? Either your own costs or the costs that are being claimed if they succeed?
The costs that they have claimed, sir, we can't pay them at this moment in time. We are in no position to pay the costs. As far as my costs are concerned, I'd like a clarification from you, sir. Does the cost include the loss of income for myself from all this framework, from these freezing orders, or is that a separate thing?
That's a separate claim in relation. I'm just talking about the costs in relation to you coming today to and preparing your documents for the adjournment and for the resisting the application for immediate judgment. Do you have any costs in relation to that?
Well, I'm not as learned as the learned counsel here. So if he's charging £10,000, sir, I'd like to think I'm at least worth 8.
Okay, all right.
What else do you want me to say? I can't. If you're going to say, tell me how you're going to substantiate that, I'll have to go to my salaries in 2016 when I was with Sumitomo and all that. It's just it's a.
Okay, you would like to claim essentially litigant in person costs?
Yes.
Okay. Let me just check if there's anything else that excuse me. Okay. Anything else at all that you can think of that you'd like to tell me?
The thing that I'd really like to touch upon, sir, is about the unfair contracts terms. We did not get time to vet these documents despite our best of efforts to get these documents. Had we gotten it all comes down to documentation, right? So the contract, it is not well written, sir. And it's missing essential foundation.
Well, I think we have done to death the
yes, sir. Other than that,
the
sir,
framework agreement.
I just want to apologize if you felt that I was putting words in your mouth. Please don't hold us against it. It was just something.
No, don't worry. No, you've done very well, and I have your points very clearly in mind, and you've done very well in the time as well. So I'm now going to give Mr. Temple the right to respond for about 15 minutes or so.
Thank you, Rana. I'll try and be brief. I thought I would just touch on this letter that we were sent by email earlier today, just in terms of what it says about the framework agreement and the facility agreement. I think Your Honour noted earlier when summarising what it says that on page 1 there is reference to the loan agreement.
Sorry, you forgive me. You have to wait till I bring it up. I just find out where it is on my desktop here. The engagement letter, yes, that's the one.
Yes.
Okay. Yes, I have that now. Thank you.
The first page highlights that the most important document is the loan agreement stroke facility agreement, even at that stage. Then moving through the letter, there's our understanding on page 2. And
sorry, where were you referring on the first page?
The first page. Please note the proposal requires an amendment which was inadvertently left out.
Yes.
The amendment we are required to add is in respect of additional scope of work, i.e. drafting of the loan agreement, stroke facility agreement. We understand this is the most important document in the entire transaction.
Yes. Okay.
And will therefore form the basis for the rest of the loan documents. So in terms of the idea that this is a very bare contract, or this is that the framework agreement was supposed to be at the heart of this, at least for the individual loan, even at this stage, it was said that the facility agreement would be the most important document. That might be said to be not conclusive. But moving forward through the document on page 2, just under the wording "our understanding,"
yes,
it sets out there in broad terms what we all know and can see from the facility agreement is the transaction. There is no, as far as I can see, on a, I should say, a reasonably quick read through, anything missing. So when Mr. Kamath says repeatedly, well, the framework agreement should have included X or Y or Z, this is positively unhelpful to his case on that, because there was apparently no central part of an understanding, if I can put it that way, from the lawyers that there should be some overarching agreement, including force majeure, or the ability to delay payments depending on what was happening in India. Rather, it is exactly what one would expect, which is that the claimants will lend the money and they will be repaid after 18 months, etc.
Mm-hmm.
On the 4th page, Mr. Kamath refers to step 2, drafting of a framework agreement.
Yes.
And the step 2 and the step 3. Step 3 being the facility agreement. Now, it looks like at this stage there was an intention that the framework agreement be where the purpose of the transaction be set out. And I'm not quite sure what the other rights and obligations, etc., are intended to be. But in terms of how the contract ends up, I should compare that with step 3, where the loan agreement was going to be the disbursement, the repayment, the drawdown facility, and the levels of security, not all of which I think happened in the end. But it looks like the purpose was to go in the framework and the details of the loan were to go into the facility agreement. But we know, of course, that eventually what happened is that the purpose ended up in the facility agreement. So the main, or the only specific thing, as far as I can see, from the framework agreement listed here, ends up in the facility agreement. So it's perhaps not surprising that something that the framework agreement was ultimately seen as not so important. And you can see the purpose in recital A and clause 3 for your notes.
Yes.
And in terms of the idea that it should have included various other things about, as I say, the ECL contract and force majeure, there is no evidence, not a jot of evidence, that this was ever discussed or suggested to my clients. Whatever was in the heads of the borrowers and the guarantors, and there's no evidence what they thought at the time either, there's no evidence that was ever communicated. So in all events, they signed the contract without the framework agreement and without those additional points. A short point on force majeure is that there is in fact specific provision for that in the law of contract, articles 82 and 83, which expressly disapplies force majeure in respect of a mere obligation to pay. And it says that where a party is obliged to pay money does not do so, the other party may require payment, notwithstanding force majeure events. That's article 82 and 83. So of course it's not legally impossible that you could contract out of that and have some broader consequence, but there's no evidence that that was ever intended, and it's fanciful to suggest that the lender would have or did agree to and I'm not quite clear what the consequence would be, whether it was write off the loan or something else. So, sorry, is Mr. Kamath? That's fine. So another point in relation to the framework agreement was the suggestion that it's voidable. Now, we don't accept that. We don't accept it has been avoided. And nor do we accept that it even could be avoided, because so much water has passed under the bridge. But in a sense, it doesn't even matter, because since Mr. Kamath was fully aware of all of these issues, they have signed the payment deed. And there's no suggestion that the payment deed is voidable by reference to the framework agreement or anything else. And that has expressed conditions, obligations for the defendants and the guarantors to pay, and that's clauses 4.1 and 4.2, with express agreement that they remain in full effect. So,
didn't your clients revoke the payment deed?
We terminated it, but it does say in its terms, 4.2, notwithstanding. So this, maybe I should take you to it, Your Honour. It's pages G167 and 168.
Yeah, okay.
Bottom of 167.
I have it.
So 4.2, if the borrowers and all the personal guarantors fail to satisfy the conditions set out in clause 4.1 and all the payment obligations in clause 2.1, the lender shall be entitled to immediately, by written notice, terminate this deed without any liability to the lender. And so it's both the termination and the ability to demand immediate repayment of the outstanding amount. The outstanding amount being defined as the principal and the interest in clause 1.4.
Okay.
So those were some responses on the framework agreement. Moving on to the freezing order, or the attachment order, it seems clear from Mr. Kamath's submissions that they were aware by November 2021 of the attachment order. So, frankly, it's very late in the day to be suggesting any of this. But in any event, we say there's no breach because clause 31.6 clearly allows us to act in other courts. And we emphasize that the word however on a natural reading is the equivalent of notwithstanding. Even if there was a breach, there's no right to set off. You've already got my submissions on that. And further, even after they knew about the attachment order, they agreed to the payment deed again. So they agreed to the repayment of the loans at that stage.
Yep.
On unfair contract terms, I've heard what Your Honour says about looking at the law. I think the law is the implied terms of contracts and unfair terms law of Dubai. It's the law, DIFC law number 6 of 2005. Not having been a point that was raised, I haven't been through that in any detail, but it doesn't appear on a quick look to mention the word guarantee anywhere. Or surety, or any, those were the two words I could think to look for very quickly.
Well, I rather suspect the Australian law to which Mr. Kamath referred is a consumer law.
That sounds likely as well. Obviously, the Unfair Terms Act or the Unfair Terms Law in the DIFC is quite similar to the English UK UCTA, so it limits exclusion clauses, but it's not a broad. On a quick review, I should say, no, it's not a broad ability to rewrite.
Well, in fairness to the defendants, given that they're in person, I will look at it.
Yes, Your Honour. Understood.
Yep. Anything else?
Well, right near the end, there was some suggestion that Mr. Kamath thought this was a 24-month non-recourse loan, and may have expressed some surprise at that point, because I'm not aware of it having been of any term sheets at 24 months. Certainly exhibits one.
I think what he was saying was that that was a proposal, but at the end of the day, it was a proposal which did not find its way into the version of the facility agreement which was signed.
Well, in that, there's nothing more to add on that point then. So, Your Honour, those were the brief points I was intending just to raise. But of course, if there are any points of Mr. Kamas that I haven't addressed that you feel you do need further submissions on,
No, I think we've pretty comprehensively covered everything. Thank you both very much for that. Mr. Kamath, you want to say something, do?
Am I allowed to counter or whatever you call what Mr. Temple has just said now, or is it done?
The general rule is no.
Right, sir.
But I'm willing to extend you as much courtesy as I can if you want to say something for a minute or two, but I am then bound to allow Mr. Temple the ability to respond to what you say. Right. So up to you.
Well, I just want to simply add on a couple of things about the payment deed. I've droned on about it, about how it was signed, what it was signed under. Now, payment deed is not a standalone document. It refers back to the facilities agreement. The facilities agreement, as Mr. Temple said, as per Emirates Legal's proposal, doesn't really matter. It does matter because it finds itself way into the facilities agreement. Eight times it's mentioned. It is said that the facilities agreement is being provided. The facility itself is being provided in the recitals based on the framework agreement.
Sorry, so we have three agreements here. We have the payment deed, we have the facilities agreement, and we have the framework agreement. So is what you're telling me that the payment deed was ineffective because it referred to the facilities agreement, which was itself ineffective because it referred to the framework agreement? Is that the point you're making?
Right, in parts.
Okay. Anything else you wanted to say?
At this stage, that's about it, sir.
Okay. Anything you want to add, Mr. Temple?
No, thank you, Your Honour.
Okay, all right. Let me just take that point down to ineffective facilities agreement. Good. Well, as I was saying a moment ago, thank you both very much for all your assistance in outlining everything so clearly. You've both given me a great deal to think about, so it will not be a surprise that I have decided that I will not give my decision immediately upon this. I will give my decision in writing. I anticipate it will be this week. And in that decision, I will also deal with any ancillary orders that are necessary unless I require further submissions upon those. But thank you both very much indeed. And hopefully you'll be hearing from the court with my decision and my detailed reasons very shortly. Thank you both. Thank you. Well, with that, we're going to close the link. Thank you.